This petition is one more petition to the customer. Using both Yogesh Kumar.
Yes.
The award is claimed the matters to refer to the authority. We have filed process one more petition challenging the award. But that's what was anytime this next week.
Gopanandam. Yes. Which department, sir? Ravi Raghunath.
Revenue body trying to construct on the future. It's
So C.H. Ravi Kumar.
Stress POS, they given their houses, lands, everything. R&R is not being done. So misinterpreting that they are not 16.
So Nandikam Krishna Rao.
Land taken for the construction of graveyard, my lord. No land acquisition procedure was followed, nor compensation.
Sir M.A.K. Mukhi.
Also for the extension of interim one.
What is the CMA?
Commissioner is supposed to be support.
CMAs are not with this court. So Rajgopalan Tai.
Your Lordship, this is for the rectification of entries in the rectification. What is the outstanding past?
Which year it was?
2020.
2020 revenue. That is not with this court. Mr. S.V. Ramana.
Private restaurant. Official respondents to report are trying to make illegal construction to a private contractor without any
Which department, sir?
revenue. And the other eviction without any date during they are two are
20th. Sir M.M. Srinivas Rao.
Matters pertaining to land counter of the file posted in the month of
estimation and continue to give here only your
Yes.
claiming work after 50 years we are like
Which year it was?
2018 work.
2018.
18 sorry
Page 1 mentioned. Page 4. Item 23 to 32. Page 5. Item 33 to 46. Page 6. Item 47 to 61. Page 7. Item 62 to 69. Page 8. Item 70 to 81. Page 9. Item 82 to 102.
number 91. This is 1620 of 2023.
Yes.
The appeal which is preferred by the government is posted for August 15th. First court. In that document, I 16.
Yes. That it was for petition. Informed other side.
I will inform.
Somebody entered appearance. Kiran.
I will inform.
Page 10. Item 103 to 114.
I'm not 9 my lord.
Yes.
Not 9 minutes under tenancy act, 40 tenancy act.
Yes.
Of course, the prices are for disposal of the
What do you want, sir?
230. The old their date.
Wait.
Page 11. Item 115 to 126. Page 12. Item 127 to 138. Page 13. Item 139 to 149. Page 14. Item 150 to 158. Page 15. Item 159 to 168. Page 16. Item 169 to 176.
172, 173, 174.
Yes.
Heard this matter extensively last week on the 3 senior council. She wanted to see the regards from the GP whether notices are being served upon the petitioner. She may kindly take up tomorrow and adjourn.
Yes. Records are there. We will ascertain from GP and then post it. Yes.
Page 17, item 177 to 183. Page 18, item 184 to 191. Page 19, item 192 to 202. Page 20, item 203 to 212. Page 21, item 213 to 221. Page 22, item 222 and 223. Page 23, item 224 to 228.
27, 28. You same that.
Page 28, item 256 to 269. Page 29, item 272 to 280. Page 30, item 281 to 292. Motion is item 1.
AGP.
Here there is a 172 item record is required. You have any instruction? Let it be in the list. You receive the record, inform the court. Yes.
Item 1. Rajesh Kumar.
This petition is filed by the land users, my lord. Land were acquired in land acquisition in 2007.
Any appeal filed?
No, there's no appeal filed, my lord.
No appeal against LAOP.
No, LAOP, there's no appeal filed. No appeal. And these are the people. Page number 171, my lord, it says the LAOP, when the matter was referred to the authority,
How do you know that no appeal is filed?
we had the respondents and the landowners.
No, if you receive a notice, then you will know. Otherwise,
Like 2007, my lord, this is 2007.
not 7. LAOP was decided in recently.
LAOP was decided recently.
Yes, yes.
And based on this LAOP, amounts are already disbursed. Amounts are already disbursed to the claimant.
You are not party to the LAOP.
He is not party to the, but I am the party to the main writ petition where my name also referred, ma'am. Page number 68, for instance.
You have nothing to do with LAOP.
I have nothing to do, ma'am. My land was also.
Get instruction. Yes. Friday?
Item 2. Relocation ready.
Same?
There is a section 31.
Same notification. Everything is same?
Same note. Same. Watch.
Item 3. P. Ramchandra Road.
Yes, get instruction. Monday. Tuesday.
Item 4. Mirza Aizaz Ali Beg.
I'm questioning inaction of the second respondent. For payment of not considering my representation. Should my kindness, page number 15, page number 11, right from 2013 onwards, I'm representing this. Material Archibald, page number 11, online representation, 12, physical, 13. Only to consider my representation claim effort. My land was acquired in the year 2000.
Yes, what years? Ingrani College, sir.
Milord.
Yes.
No.
Ingrani College, instead of papers. Complete issues.
Correspondent fingering.
You are paid compensation for the land.
And only by shed, and that is admitted by them. Actually, I'll tell you, it's page 13 and 14. Two borewells and one shed compensation was not paid right from 2013, 28 onwards. I am making representations. And information was also up to the technical department. Page 15.
I pass it over the. Let me dispose of it. Yes. It's the stuff. Please, we are sharing it. And we see what is on it. Don't, if possible, get instructions. It's only to consider it. Yes.
Item 5, Venkat Prasad Ukalam.
Yes.
This is relating to the widening of the national highway from 4 lane to 6 lane. From Tonduru to Patapati.
On what ground you are questioning?
I no notice from it.
No personal notice will be issued in this matter.
It's notification, PA notification. They said that 7/220/3. I approached the company letter. And he said yours is 223/RE. So he doesn't come under, we are taking only part of it. He was come under behind, you don't worry. We did not do anything. Later on, when I
Where is the meeting file to show that you approached them and
there is I find one representation here. It's in page 359, volume 2.
next
There are
volume.
2 volumes. My grievance is against point number 6 and 7. After letter. Page number 35. Dated 1st August 2020.
Who is the competent authority?
Complaint that is the additional collection of the addition. That's point number 3.
This you submitted in August 23.
When the government I came to know, we submitted. We came to know that award is also passed and they came to demolish my wall in the land. Then we ran to this complaint authority. He simply said, you go to the court.
Yes.
Notification to the court. 3G and 3G also.
Compensation paid.
Yes, paid to my predecessor owner. Yes, the title is some difficulties there. He did not make any objection because it's a windfall gain for him. He did not object, he has taken money. That survey numbers are mentioned.
Let them file count.
Otherwise, these people, they don't react to that. That's a
This
problem.
is all public purpose and award is already passed long back.
Acquiring land, I have no objection to that. I have no objection.
It's only about compensation.
Only about Thomas.
Then we can decide that later.
But the owners also to be mentioned properly because they are taking wrong old record. They
You
did not-
impleted them.
Huh?
Did you implement them?
I implemented them. I implemented all.
Where?
The respondent number 6 is land acquisition. 7 is passenger.
That your predecessor and title were impleted who received compensation.
Private parties not, and they were not implemented. They are
Why?
private parties. I did not know also whether they actually they received or not because I am only the authorities they were telling me.
Regarding Praveen Kumar and deputy solicitor general of India takes notice for on number 1. You are taking notice?
Second, third, fourth. I have no grievance against them. I have grievance against them.
Takes notice for experiments. 3 to 4. AGP for investigation takes notice for 7. Next. 6 weeks for counter. ఇవన్నీ ఏమవుతాయి మరి మళ్ళీ దానికి ఇంకో అమెండ్మెంట్ పిటిషన్ ఉంది
Personal notice.
Every person notice తీసుకుంటారు. All of them are represented now by council here.
Second, third, fourth.
Yes, yes.
Item 6,
1812 for counter.
Yes, ma'am.
A. Narasimhareddy.
Yes.
Petition Bati that will not who is secretary GP holder. After filing MP petition on the purchase of petition Bati. Friday, stop.
What is that?
Petition Bati that will not. Petition number 2 is equal to GP holder petition Bati. After file the file for petition number 2. And second, moreover, filing petition on the purchases who purchased the petition Bati is no more now. Finally, Friday was back. There's a default order not right to. Last week, you also passed order that meet of application not filed. The petitioner should decide to upload not, I could not get instruction.
It's already over. Operator will operate.
That's the appropriate applications.
That you can do it. Yes. Who appears for
4 to 6 Lord, I have also kindly posted same caption.
you argue in respect of other two petitioners? I'll hear the matter.
Yeah, so filing application in subsequent purchase or purchase petition. All I'm requesting on Friday will not accommodate me.
2005 matter and 1610 you are granted time finally.
I'm aware of this plan.
We can't be listing these matters and again specially identified, listed several times from April onwards.
I'm aware of this.
I dismiss for default, you file appropriate application.
Friday.
If you are not ready to argue the matter, I'll dismiss for default. No, we can't keep these matters pending unless we adopt such procedure and no matter is being disposed.
Friday, but I not I not take any just beyond Friday. I file appropriate application by Friday and lost my and same caption. Friday, but not beyond Friday.
See, now you want to implead somebody and notice has to go to them. And again, it will be there. I'll dismiss for default order. No, this matter is of the year 2005.
Otherwise, I'll go ahead with what someone petition about appeal of appeals.
See, we can't give grant time to you for filing future applications and for consideration of those applications.
Request so much petition, but please do not petition, but to have to file appearance. Friday file appearance.
How can you file appearance for a dead person?
Petition, but two now who is dependent GP
It's all your look. No, this type of things we can't.
Only Friday. I'll not.
Sorry, you can file along with all other applications. You can file registration application. Yes. No, this matter is of the year 2005, and sufficient time is granted. The legal representative.
4 days.
Respondent number 3, petitioner number 3, and a conditional order was also passed on 16/10/2023. In spite of the same, no application is filed to bring on record the legal representatives of deceased petitioner number 3, nor the land council for the petitioner is ready to proceed with the matter. In the circumstances, this court is left with no other alternative. But is taken into consideration the fact that this petition is of the year 2005. This court is not inclined to adjourn the matter on any count, as the land council for the petitioner is not ready to proceed. If you are ready to argue the matter, I'll hear. Please. You saw the observations of Chief Justice of India.
I am also embarrassed to make this kind of.
Chief Justice of India observations you saw in 2005 matter and.
I understand. I am also embarrassed to make this kind of request. But at least Friday, not beyond Friday. Possibly can impose some cause on Friday, not impose some cause
Finally, post the matter and the caption dismissal.
on some terms. It's a bit on Friday, not.
So, 3,000 to the. Yes. For dismissal on Friday, subject to payment of cost of rupees 3,000 to association.
Not sure.
Your lordship will put it up to Friday by this 12th day, sir, that is there.
It's Monday.
Tuesday, Monday being holiday.
Yes, Tuesday.
Yes.
Item 7, M.V. Pratap Kumar.
Serial course later was not possible. 5-10 minutes. Account.
Paper book filed?
File, book is already filed.
Then paper book. Also. Keep the paper book ready, sir. That's the direction given last edition. In the.
Item 8 to 13.
My lord, items 8 to 13, I appear in item 10. Your lordships have already heard Mr. Adinarayan Rao extensively. My lord, I just have a quick 3 or 4 minute supplemental submissions to make without repeating what was argued, my lord, by my senior friend, Mr. Adinarayan Rao. I'm sailing along with the petitioners. My lord, I am the subsequent purchaser having interest and having the same cause. My lord, just the 3 additional points I want to raise.
Yes.
My lord, first point, my lord, when the acquisition the government says is for the purpose, for public purpose,
Yes.
the professed public purpose, your lordships, is housing.
Yes.
Because townships eventually provide only for housing.
Yes. Yes.
If what is being acquired is the same house plots belonging to people who want to use them for constructing their houses.
Yes.
My lord, to say that the land is being acquired, my lord, for a public purpose possibly will not be the purpose envisaged under Land Acquisition Act. This is my first point.
Please repeat.
My lord, if the land as it is itself house sites being proposed to be used for constructing houses,
Yes.
government cannot say, I want to acquire the land for housing purpose.
Yes.
Because the purpose is the same already. The land is already being used for housing purposes today.
Yes.
So Land Acquisition Act is not for that purpose.
Yes.
Enabling, my lord, eminent domain power. Now, just to give an example,
Yes.
suppose, my lord, there is an industrial estate. Industries are functioning.
Yes.
Government cannot say, I want to acquire this land for setting up an industrial estate.
Yes.
My lord, I can understand if the government were to say that in this area there's an industrial estate functioning, there are industries functioning, but we think this area is best suited, my lord, say for a specific industry, say textile industry or software industry or fabrication industry. Then it may possibly mean, my lord, that despite government knowing that the land is already used for industrial purpose, a different industrial purpose is sought to be achieved.
Yes.
So, my lord, in the present case, these are, my lord, employees, industrial employees who formed a cooperative society. They want to use the land for housing purposes.
Yes.
The Land Acquisition Act notification saying there's a public purpose for which we need to take the land away from the landowners, my lord, does not stand to reason. My lord, this is the first point.
Yes.
My lord, this may constitute a colorable exercise of power.
Yes.
Lord, Mr. Adinarayan Rao had already argued for your lordships that this seems to be, my lord, in the nature of some real estate business Huda and government want to do rather than actually achieve housing purpose.
Yes.
So, my lord, I'm relying on Mr. Adinarayan Rao submissions for colorable exercise argument. I don't want to repeat, my lord. My lord, second point, the land acquisition proceedings must fail because no attention was given, my lord, either by the government or Huda to the fact, your lordships, that earlier there was an acquisition proposal similarly for housing purpose.
Yes. That was also argued.
Already argued. Yes.
And the GO was issued withdrawing the acquisition proceedings.
Yes, Lord. I'm not repeating the facts. The only simple point I'm raising is no record shows that government's attention was cognizant of this fact that earlier there was a housing acquisition which was dropped, notwithstanding dropping of housing acquisition. Because, my lord, the purpose anyway is for housing. Government decided to go on regardless.
Yes.
But I'm only saying that when government is deciding to acquire, it must be fully cognizant of the previous facts.
Yes.
Now, this record shows government has not applied its mind. Mechanically, my lord, Huda submitted proposal. Government is now telling your lordships that we had asked Huda to identify So Huda identified and gave this proposal, and therefore we have instructed Huda to proceed.
Yes.
But nothing is there to show that either Huda or government were taking into consideration, my lord, that this earlier acquisition proceedings were dropped, notwithstanding that they want the new acquisition to start once more.
Yes.
So, my lord, non-application of mine
Yes.
at the stage of government or Huda deciding to initiate acquisition.
Yes.
So, this is the second argument, my lord.
Yes.
My lord, the third argument is the specified point of township, establishment a township, would be more vague. My lord, Mr. Adinarayan Rao had already argued that this is a vague notification. My lord, Mr. Nagarjuna Reddy's judgment was shown to your lordships that similar notification given earlier would not come within. But I am only saying it will be even more vague in the present case.
Yes.
Because there is nothing that is shown, my lord, as to why a cooperative housing employees' land, which is set apart for housing itself, is now being acquired.
Yes.
My lord, fourth point and the last point.
Yes.
In the counter affidavit filed by them, they specifically say that yes, we know that this land has been transferred to further persons. Those further persons can come at the compensation stage and claim appropriate compensation. My lord, notification did not take into account these rights that have, my lord, been transferred.
Yes.
So, my lord, the entire exercise of deciding to initiate acquisition, the manner of, my lord, issuing a notification, not five-way objection, consideration. My lord, if your lordship see, my lord, the manner in which the five-way objection was considered,
Yes.
that order which is a part of the record clearly shows that even in five-way, my lord, after they were informed, that I already argued, that
Yes.
prior to issuing the notification, they had not taken into consideration the earlier proposal and dropping the proposal.
Yes.
I already argued, my lord, they also did not take into account the fact that it is already being used for housing. So what is the point in acquiring for housing? Before 4.
Yes.
Now I'm making the next argument, my lord, that all right, maybe they were blind, they were not aware. But 5A, once I filed objections and brought this to their notice, at least at the 5A stage, my lord, they have to take these factors into consideration, and the order must disclose why, despite now being made aware that the land is anyway already earmarked and is proposed to be used for housing, is still required to be acquired, my lord, for housing. So both at 4 stage and a later 5A and section 6 stage,
Yes.
complete non-application of mine.
That will result in sending it back.
My lord, result would be, my lord, quashing the notification. Because yes, yes.
5-year then.
No, my lord, no. I'm saying therefore 6 must also go for only one reason. My lord, the argument I am making is, once, my lord, the court is made cognizant of the fact that these are housing plots where an earlier acquisition proceeding for housing itself was dropped because they understood that these people also want to put it for housing.
Yes.
And conditions are imposed. You will take only one layout approval. You will use it only for housing.
Yes.
New notification, my lord, is a repetition of the same earlier notification which was dropped.
Yes.
This is not the purpose of Land Acquisition Act. Not only when your lordships, my lord, I'm putting it on 2 grounds. One, as an absolute principle, you cannot resort to land acquisition for subjecting the land to the same use because you are benefiting. Government and Huda wants to benefit as a trader.
Yes.
If the acquisition has to go, but even on the process they followed, the court, if it's persuaded by my arguments, can fault the government in the way, my lord, they have not even put their mind to this, either at the section 4 stage or once it was brought before them, before the 6 declaration stage.
Yes, I followed. Yes.
So therefore, 4 and 6 both must fail.
Yes.
My lord, therefore, to summarize and conclude, my lord, the entire acquisition proceedings are misconceived because the public purpose objective for which, my lord, eminent domain power is given
Yes.
It's something that the state is trying to use as a ruse for the purpose of taking the land. And very importantly, this is the last submission. In the counter, they admit that they cannot rule out giving it to private developer. They will not rule out selling the land by public auction. Which
Admit-
would be
admit on
government tender.
They admitted that they are going to give it to private public partnership.
Correct. And they want to auction the plots.
Yes.
So, this whole exercise, therefore, I said, it's a colorable exercise of power where the government ends up profiting at the cost of poor plot owners, not the object for which Land Acquisition Act or Urban Development Act, conceives or envisages that public purpose acquisition can happen.
Yes.
These are my supplemental submissions to what Mr. Adinarayan Rao argued.
Yes.
But I'm grateful, my lord, for your lordship's granting me the opportunity.
Yes. Yes. Yes.
One of the including petitioners.
Yes.
Only one point I want to clear. 6 years after giving the acquisition notice, my flat has been regulated by the different ends under LRS by collecting 90,000.
You filed include in which application?
It is
Which writ petition?
Act from 10,
What is the number?
1/21.
WP number చెప్పండి.
WP 4867 of 2007.
IA number?
IA number 1 of 2021. And in this LRS proceedings, they would even go on to say that all the proceedings initiated against this plot are withdrawn.
1 of 21.
Yes, madam.
Is it shown in the list? What's your name?
K. Lakshmi Narayana. Kalyani Lakshmi Narayana. Find a booklet like
Your application is not there in the cause list also.
this.
You filed that LRS? LRS proceedings you filed?
Yes. Page number 20 and 21. They collected, and I don't know how many people have paid this. I was in Delhi, I was not aware about this proceeding. Delhi I applied. I was working in Delhi. Page number 20, 21 of the last proceeding, 19 and 20. The respondents were utilized that process. The last paragraph says further all proceedings and action of enforcement of by HMDA initiated or contemplated against this quarter are withdrawn by HMDA. We have been waiting for 37 years to build a house.
Yes.
But as I understand, for public private purpose, only government lands and assessments can be taken, not the private properties.
Yes.
Actually, ready with the matter investigating, the meetings are missing. By Thursday, minutes will make our submissions. We file the comparison judgments.
Take it from the file, whatever you want.
We collect the minutes. Thursday minutes will make our submissions.
How much cost? All these matters and special identified unless
Thursday minutes finally. First minutes, that would matter.
that's the reason why. Yes. You are arguing the matter?
Then advocate general.
It's like a combination. Take up the matter on first step. Is made clear that no further adjournment. No further adjournment.
Item 14, Y Ramarao.
It is matter pertains to cancellation of Latam. I know that the request for adjournment in specifically identified cases. Due to personal difficulties with Madam and there's a lot of consumers. So this matter a big minutes.
No, already accommodated.
Yes.
On your request, matter was adjourned once.
Yes, minutes. Just
From 17:10 to today.
yes.
Yes.
Non-stop it is having
You should have get ready and what.
Also, the clients also needs to follow up with us. We have tried contacting.
How much cost? Yes.
Have a gap with minutes instead of a week.
Then is per day 1,000 rupees. How many days you want? Tomorrow?
Tomorrow.
Yes. What is this matter? The previous proposal date. Listed in the caption, especially identified cases. Adjournment. What is it? Close the matter. For dismissal tomorrow, subject to payment of cost of rupees 1,000. HIGHCOURT Advocates Association. Yes. Yes, for dismissal tomorrow, cost 1,000 rupees. Yes. Passover? Passover. Yes, Passover.
Item 15, Mrs. Indus Law Firm.
Kindly pass over the matter.
You are for?
Senior is held up in other court.
You are appearing for who?
Petitioner. This I'm for respondent.
Yes, Passover.
Item 16, K. Mohan Road.
Yes.
Disposal of the respondent petitioner different in the food ministry. The respondent did file food for the petitioner as a petitioner.
Petitioner is the plaintiff.
Petitioner is the different. The respondent is the plaintiff. He filed suit for Indian as the petitioner and others. Thereafter, he appeared. Thereafter, we file appeal in the district court. This is number and 47 of 2015. Thereafter, we filed a special petition. While the appeal is pending, the respondent is finally interpreting the petition. Only for the details of the disposal of the agenda.
When you filed appeal,
It is filed 2015. 8/2015. Because of the non-suspension of the judgment, case is and the interfering with the portion of the district connection, taking advantage of judgment and the construction. Interference to dispose of the agenda.
no, what happened in the IS so far?
It is pending.
What happened? You took time, other side took time, or court didn't take up?
Not we are pushing that. We are ready to avoid ready to.
No, any docket proceedings are filed?
Important. Yes, to suspend. Every club application has to be served within 1 month.
What happened? You should say
Only our notice is.
pending. If you have taken time so many times, then on what ground it is being adjourned?
Only pending matters. So May onwards.
You file docket proceedings, then I understand. If you are not responsible for the delay, then I'll direct.
Yes, sir. I'm always letting you know. Now it's
File the docket proceedings.
so now taking advantage of judgment taking is interfering in my question.
All that you can agitate there. Huh?
Not filing meeting, actually is taking advantage of judgment is
You
interfering.
file your docket proceedings from day one of filing of your application. File your docket proceedings tomorrow. What happened from the date of filing of the appeal? Yes. Tomorrow? Yes. Certificate copy not required, you can file.
We will file online report.
Yes, yes.
Item 17, B. Ravi Kumar.
Please, your lordship.
Yes.
But the division filed against order passed by the lower court, saying the petitioner being the defendant paid the lower court to send the suit pro note for expert opinion by comparing the signature of the admitted signatures along with the disputed suit pro note. That petition was dismissed by the lower court. I filed this present division, paying the Honorable High Court, but giving a direction to send the disputed document to the expert and they decide the suit. But the petitioner, the suit is filed on the ground that an amount of rupees 9 lakhs was borrowed by the petitioner. But petitioner, the division petitioner states that she never borrowed and she has no necessity to borrow the amount. The facts reveals that the respondent, the present petitioner, division petitioner, who is the defendant in the suit, has got huge property, 2 houses, and she is well off. Whereas the person who filed the suit, Chandrama, was not having any property and her husband is only a mason on the daily basis. Therefore, may not there is any amount of dispute rise. But the only way of proving the document, because by accusing any number of witnesses that she has not borrowed the amount, will not support the defendant case. Having left with no choice, she filed the present petition. In fact, the burden of proving the suit pro note lies on the plaintiff, but the plaintiff did not choose to file the present petition. Therefore, the division petitioner was compelled to file the petition.
On what ground did the trial court refused?
Trial court refused on the ground that the signature can be compared by the court under section 73. No, there is no dispute for the cover, but it is a settled principle.
What is the stand of the plaintiff?
The last that same ground appeal IAS filed in 2018, my lord. In that, the last time is the order 2018 IA.
Same order, my lord. The earlier the documents were not filed. There were no supporting documents, no immediate signatures were present before the
The
court.
last time kindly see page number 3, 9th paragraph.
But it was
The lordship that the defendant has filed a written statement on 9/3/2017 and the IA was filed in 2018, my lord.
your
The
lordship,
magistrate has compared the disputed signature with wakalat as per 73 of the Evidence Act and the same was disputed. And on the same ground they have filed in 2023 the same ground for the comparison of
Read that portion. Where is that?
page number 3, my lord.
Yes.
Para 10. Further, section 73 of Indian Evidence Act empowers the court to compare the disputed signature in order to ascertain whether a signature written is that of a person by whom it purports to have been written or made to come to a provisional conclusion. Further, there is a record, summons, notices, written statements with this court and this court has stated above as ample power to compare the signature with
there is no
disputed one.
dispute, my lord, in this.
Please wait. What is it?
Even on appearing signature for comparison of this court to a provisional conclusion that the signature of the petitioner defendant on a wakalat and signature on pro note appear to be same. Therefore, as the petitioner has come with the petitioner at the fag end of the trial with inordinate delay, and the above observation made by this court empowered under section 73 of Indian Evidence Act led this court to come to a conclusion that the petitioner defendant has not proceeded genuinely to send the pro note to handwriting expert, but for drag on the matter for the pretext of expert opinion. Therefore, the contents of the petitioner does not inspire the confidence of this court, hence the petition is liable to be dismissed. And in 2023, they have filed the same IA saying that to send the signature for the expert evidence. And the same are dismissed. You will actually may kindly see the last thing. Last may permit to be para 9 of the IA.
Yes.
Page 12 of the federal facts.
In view of the above facts and circumstances of the case as well as pursuit of record, it is admitted fact that the main suit was filed in the year 2006, and also it is an admitted fact.
2006 or 16?
13, my lord. It is a 16.
2016 suit, my lord.
Yes.
It is an admitted fact that the petitioner defendant has filed a IA number 470 of 2018 before this court under section 45 of Evidence Act, read with section 151 of TPC with a prayer to send the disputed signature, suit pro note and admitted signature to the handwriting expert for forensic laboratory. However, in the IA, the respondent plaintiff has filed counter and the said IA was dismissed on 11/11/2021. Further, again, the petitioner defendant has filed the present IA with the same prayer, and the present IA is not maintainable in the eye of law and comes under the res judicata. Moreover, the petitioner defendant has to file the appeal to or revision seeking to set aside the dismissal order. On 11/11/2021 passed by this court in IA 470 of 2008 was dismissed. Therefore, it is not maintainable. It also applies res judicata. The present IA is filed also with the same prayer which was in the 2018 manner. That's why it attracts the judicate of 60th page is the prayer of the IML. In that they have already admitted that
My lord, you see, in the present case, my lord, the earlier it was during the period of Corona, my lord, and there is at that time exhibit B1 to B3 were not marked and not filed, my lord, and therefore the petitioner cannot send the documents unmarked, which are not filed. Therefore, in the changed circumstances, the present petition is filed, my lord.
No, court already said, and 73 power can be exercised, and court already compared that they are recorded a finding that they are similar.
At this time of when I am disputing the signature, my lord, 73 signature cannot be used at the time of interlocutory application.
Then that order was passed. You allowed that order to become final.
That is interlocutory orders will not they will not be the adjudicator for interlocutory application.
So you can file again and again same application.
No, but changed circumstances, I filed.
What is the change in circumstance here?
It would B1 to B3. The documents were not filed at that time, my lord.
Is that the ground on which of the earlier application was dismissed? Earlier application was dismissed on the ground of non-availability of the admitted signatures.
No, here also the same thing. 73 signatures can be compared by the court. It was not considered. My submission to your lordship is 73 is an expertise signature comparison may not.
When expect B1 to B3 were marked?
Subsequently, may not recently in 2020 when the defendant was examined. I tell you what.
It's not as if you can file up.
21st, your lordship may see, they were marked on 21st of June 2023.
20?
Recently, after when DW1, it is the petitioner's burden when a document is disputed. And when the signature was disputed and vehemently said it is a forged one and a fabricated one. When the petitioner is saying it without taking any steps by the plaintiff, he proceeded with his own evidence. And during the period of Corona, when her husband was also lost, when the courts were not running and then the documents were not there before the
No,
court.
instead of filing another application there, you could have filed CRP then itself.
My lord, it's a technical lapse on the court, and that too, that time your lordship would have said, where is the documents that you have filed? My lord, that is,
No, that you cannot assume grounds and
my lord, your lordship may kindly see, there is now no harm, it's a matter of 2016, my lord, if your lordship sends the document, within 2 months, the expert opinion will come. And if expert opinion is against the defendant, my lord, defendant is bound to concede to the suit and pay it off. It is not that defendant is interested in dragging on the matter. And your lordship may.
what is there to show that those documents were marked only in June 23?
DW1 evidence. DW1 evidence was recorded on 30th 6 2023, my lord.
Where is that?
That I am not finding the report, my lord, is there with me. The defendant.
The last week kindly see page number 3, my lord. They have filed a written statement on 9/3/2017, my lord, and the court has compared the signatures.
Can court compare that stage? In an application filed under 45, court will record a finding that signatures are similar, no need to send. I will eschew that finding and I will leave it open to the present judge to deal with the matter.
Your lordship may kindly see one simple principle. Just the Honorable High Court in Chaitanya.
Earlier order will come in your way. CRP itself.
It's an interlocutory application, my lord, is there no adjudicator for interlocutory?
See, once you file an application with a particular prayer that was rejected by the court, you cannot file another application on the same ground.
But there will be no adjudicator and interlocutory applications, my lord, on section 11.
So, why can't you file one more application there itself? Why you file CRP now? You file one more application there.
He has taken a decision, my lord, already the present officer, the exhibit B1 and B2.
Earlier no decision.
I will say.
No, earlier no decision taken.
But because the change in circumstances, I opted for it. Because at that time my evidence was not recorded. Your lordship may please, your lordship may kindly see the Honorable High Court in Chaitanya Housing. Your lordship may bear with me for 2 minutes.
Yes.
At least in Chaitanya Housing, when a single judge went to file this document for sending an expert opinion, the Honorable High Court, single judge report to the division bench.
Place that judgment. If they have anything they want to rely upon, place it. Yes. Yes, sir.
Your lordship may see when to file a petition, the prolonging the suit and filing a petition at the stage of argument or after DW1 evidence, the court need not. The petition can be filed at that stage also. It cannot be dismissed on the ground that it is filed at a belated stage. That is what the Honorable High Court of Division Bench has held it, my lord. Your lordship may peruse the same by answering it.
Where is the division bench judgment? Which one you want to rely?
Chaitanya Housing.
First judgment is the Calcutta High Court.
Calcutta High Court, that is next.
Can Chaitanya also?
Yes.
Their lordships, at para 4, consider the defendant while I under 26 rule CPC and so on so. Stand the pronote. Then their lordships at para 6 said the first is that it was filed at a belated stage, and second is that in view of the existence of powers in the trial court under section 73 of the Evidence Act, it may not be necessary to execute the request to send the document. It is at the para 6, my lord, at bottom of the para. Then, my lord, their lordship of the dispute document must be sent for an expert opinion shall be kept to open. Their lordships it did not answer that issue because it's not referred to. The reference was only to the question whether it can be filed at the stage of argument. Then, my lord,
No, that was held by division bench.
yes, madam. The division bench.
ఏం చెప్పారండి అందులో ఎక్కడ చెప్పారు అది ఏం చెప్పారో చదవండి అది
At para 6, my lord. Para 6, my lord.
yes
At the second part of the para, the lordship got it. The first is that it was filed at a belated stage. The lordship got it.
that they referred to another case
That they discussed.
and that case was discussed there. That is not what is held by division bench.
The last para 9, your lordship may see at the end of the judgment. No time could be fixed for filing applications under section 45 of the Indian Evidence Act for sending the disputed signature or writing to the handwriting expert for comparison. Your lordship got it.
Yes, ultimately the division bench said such application can be filed anytime and subject to discretion of the trial court.
That is the point on which it was referred to.
Yes.
Well, then your lordship may refer to the judgment of Punnamaneni Nageswara versus Punnamaneni Vesankaramaya.
Yes. Yes.
Your lordship may. Here also the same expert opinion, the lower court has dismissed the application, and your lordship may come to the where I.
No, if earlier order of the trial court was not there, I would have considered all this.
That was clear, my lord. She is an illiterate, my lord. Your lordship may.
He is not illiterate. Don't say unnecessarily things here. How do you say she is illiterate?
She has nothing, my lord. She housewife, my lord. She is not doing it.
So all housewives are illiterates.
Your lordship may say, within 2 months she will take all the.
She signed in English, so much perfect perfection in English, and you say she is illiterate. Yes, ma'am.
Not your lordship, but directly within 2 months I will complete, my lord. I will take that. I will take the.
This application itself is not maintainable.
She will take the personal responsibility, my lord.
Suresh Kumar, చేయొచ్చు అట్లా?
Yes, that is why your lordship said the second petition is maintained. Because first petition, I think he has not taken it in revision petition. I agree that has become final between the parties.
No, I am of the view it should be sent for expert opinion. But earlier order,
Clear order.
that order is allowed to become final.
Agree with that. Once a petition is filed, but whether it comes under the certificate, change the circumstances have to be used before the court, rather to change circumstances. that it all depends on the pleading. Pleading, you know, what is the plead, what is the present?
No change in circumstances. Admitted document, if not on record, while along with 45 application, we are supposed to file all such admitted signatures and then ask the court to compare.
They were not marked, my lord, at that time because evidence was not recorded. That is the change in
Mark కాకపోయినా వేయచ్చండి 45 application marked documents పంపించాలా? Admitted documents can be sent.
evidence of evidence, my lord. It is only change in
16 suit, 16 suit, no question.
I submitted to your lordship, satisfied with your lordship. May kindly show Nishpati and ask only 2 months, my lord. It is not a bold matter, my lord. It is not even a bold suit.
16 is not old. Money suit and 16 onwards, you are dragging it successfully for 7 years.
Yes, Corona, 2 years, Corona blocked it. I will do it within 2 months, my lord. Your lordship may restrict it.
Civil division petition is filed against an order dated 6th September 2023. Passed in IL 86 of 2023. And you got this copy on 16th September. And when you filed CRP?
29th.
Invoice number 6 of 2016. Court of the High Court District Judge.
You are 2 months back. Yes.
The application filed under Section 45 of Indian Evidence Act was dismissed by the Land Trial Court, mainly on the ground that the very same petitioner on an earlier occasion filed IA number 470 of 2018 with a similar player, and the said application was dismissed by the Land Trial Court by an order dated 11th November 2021. Copy of the said order in IA number 470 of 2018 is placed before this court by the Land Council for the respondent. The petitioner of the said order discloses that the very same request made by the petitioner was negated by the Land Trial Court by making an observation that the trial court in exercise of power under Section 73 of the Indian Evidence Act can compare the signatures, arriving at right conclusion, and also made an observation that the signature appearing signatures of the petitioner on the Wakala, signatures on the owner appears to be the same. Thus, the Land Trial Court dismissed the said application. The petitioner hearing allowed said order to become final and is not carried the same in division before this court. Once an application is filed for the if the same player was dismissed by the Land Trial Court by giving reason, petitioner is not entitled to file another application for the same relief, and the Land Trial Court rightly dismissed the application number 180, IA number 186 of 2023. The concept of the petitioner seek to place reliance on various decisions of this court. In the case of Janachitana Housing Limited versus Divya Financiers, engaged to the town. That's in CRP number 3592 of 2018 in support of this appointments. No doubt, this said they should have considered the circumstances under which a disputed signature or writing can be sent to expert opinion under section 25 of the Indian Code. As the application filed by the petitioner under section 45 was already decided by the trial court in the very same suit, and the same was allowed to become final. The same, the petitioner cannot be permitted to re-assert the same at a subsequent stage in the very same suit. In the circumstances, this court is not declared to be the CRP, and the same is accordingly dismissed. However, it might clear that this court is unable to acknowledge the so-called prima facie finding recorded by the trial court in its order in IA number 470 of 2018, in voice number 6 of 2016, dated 11th November 2021, stating that the signature
Item 18,
In case you listed, the last occasion, people specifications compensation in this, we filed a counter stating that it's at the award stage. So last occasion, vouchers are directed to get instructions whether any award has been transferred.
Okay.
Till date, no award is not.
Still you have time.
The grievance is not to release compensation. Not to release
Did you-
compensation in favor of.
What's your stand? Did they submit objections before you? What they say in the counter?
Say that the R6 also filed a petition method and requested to stop the payment because there is a dispute. Petitioners and the R6, both of them. So in view of that, as the case has been pending before this wonderful court, award could not be passed. So your lordships can may dispose of the stating to pass the award and refer it to.
Where you said that R6 also raised objection?
Yes. Page 7, paragraph 6 method. The petitioners herein and R6 have filed petitions on 6/5/22 and 7/5/22 and requested to stop the payment compensation till disposal of land dispute amongst them. Accordingly, they have informed by this memo that only it will be considered only according to their title. It would be examined at the time of passing of award. But when I inquired Milord and I called this, they said that they would pass because it was pending before this honorable court.
So they said they will refer it to the other.
Yes, because there is a title. October, Milord.
R6 is served with notice.
Yes, Milord.
Including surveillance. Question is fine. Second, the techniques. Declare action response into four. Proposing to pay compensation. The foot of land and matching 1/16 units.
And you try count on that coming from count. They are speaking time per count.
When?
Next one.
Speed for filing count. Yeah. Yes.
Inspection.
It was already explained.
Yes. 3/10/2023. That this time they conducted.
Copy or forward the statement.
Did you raise any objections under 11.1? 11.1 లో నోటీస్ ఏమి ఉంటుందండి? న్యూమరీ నోటిఫికేషన్ తర్వాత నోటీస్ ఉంటుందా? పర్సనల్ నోటీస్ ఉంటుందా?
I made a representation in the month of April. Even they are not given any award copy also, madam, my client went to the office.
Award already passed?
Yes,
That's what they are
one is passed, dated 2/8/23. For an extent of 191.8 square yards. Can I pass the award copy? The serial number 1 is there. Page, the serial number 1, caption of case and title. Census number 18-13-132/37/A/1. But in the affidavit, it is shown as by B.
Page 49, but then for 2020, before the award, madam, I made an assessment.
Page?
14. Respect in public room. Stating that the owner of the property houses for paying the gross function 191.8 square.
This is after the declaration.
It appeared that the declaration.
Then
But the event of the petition, only one side they are acquired, that is the events, I'm not opposing the acquisition of the land. Earlier also acquired, it's the second time.
they say that some technically there was something. Paper publication is not by publicity. You know that it is being acquired. Award is already passed. Then you, unless you question the award and
Liberty may be given
yes,
the award. Copy may be. I'm not having the copy.
I'll submit.
action. Segment 191.08 square yards. Situated under the dimension of without considering the location. Yes, yes.
Item 21.
What copy?
No.
Got the copy?
Yes.
Have given.
This is the matter of valid instructions. The petition.
Yes, CPR.
If grievances in this not will give any expression. Grievances that
This is not acquired is their case.
Yes, but.
This is not acquired and they have passbook in their name.
Yes, but. And also, I know the people which the petitioner is wanted to give.
What is the difficulty now?
They are not allowing us to register the gift deed.
is their revenue has to.
No, well, they're saying that well, because it is acquired. So first they have to say well, whether it is acquired. After the records, well, it's not acquired. If it is not acquired, they have to register.
GP for takes details for that. Who appears for 5 and 6?
Even 6 standing council. Standing council.
Miss agree maybe. Standing consultation is for Pardon? V. Umadevi, the name is written here. R. Thermal power station. Kakadiya Thermal Power State Project and Telangana State Power Generation. Power generation is not Vinod Reddy.
Generation is the power rate.
Pawan Reddy. Not Pawan Reddy. To see it appears that the subject land was not by the respondents. Right at the middle section down, right to extent into 22 numbers. Note exceptions are there furnished to the learner. GP for land acquisition by the response. The sections different direction are great.
Item 22 is now presented.
Let subject to your lordship's kindly, my lord.
Yes.
That this is a matter, my lord, where the land acquisition, my lord, urgency clause was invoked and notification of 2000, my lord, year. And then, my lord, they have issued a draft notification in 2001, paper publication in 2002. My lord, award was passed in, my lord, February 2002. My lord, petitioner never had information, my lord, until notices were received by him.
18 reference.
My lord, reference, my lord, application was made on 4/2/2004. Application was made for seeking for reference under 18 for enhancement. He received the compensation, my lord, in December 2003.
Yes. What they say in the counter?
Lord, they're just taking the same ground, my lord, what was argued before the, my lord, while the interim order was granted, my lord, interim order was already granted, my lord, directing the respondent number 3 to refer the application under section 18. Whatever grounds they have argued there, they just put it back in the counter. They said that my lord, a GPA holder has sold the property and other grounds. But my lord, they have not got, the facts are not in dispute, my lord. The application was made, the petitioner, my lord, received compensation on 11/12/2003.
See the counter.
I'm sorry, my lord.
Let's see the stand in the counter.
I'm sorry, my lord. The counter, my lord, copy is not in the file, my lord. That's not given to me, I suppose. But I was informed, my lord, that they have taken the same grounds. I had to quickly ask them what was the grounds.
Yes, yes, sir.
I'm sorry, my lord.
They say this nobody claimed during award inquiry.
My lord,
Compensation with respect to the subject property award was passed on 28/2/2002. Then petitioner thereafter approached and compensation was paid on 11/12/2003. Then he made a request on 4/2/2004 within 2 months. 4 within 2 months. 12/2 notice is not served. Yes.
my lord, even the original notification, my lord, was issued on 12/12/2000. I mean, originally, my lord, the
You are
publication
asking
was.
the difference.
They have issued an errata in November 2001, adding my survey number without notice to us, my lord. And within the paper publication came to be published on 20th February 2002, and award was passed on 28/2 within 6 days.
You are not questioning the award.
No, my lord, we are not, my lord.
You
The
received already
opportunity was not
compensation.
there for us to
Immediate
approach them.
evidence. Yes.
I'm obliged.
Property. The petitioner measuring 3,073 square yards. Situated in survey number 209, Mandipadi, village, Siva. Receive copy of this.
I am grateful, my lord.
Ready? Yeah? No, if you are ready, I'll give the matter. Yes. The side.
That's why many councils seem to be there. In the morning problem, somebody seems to get a 7 mark person. Every matter, I think they should contest this matter according.
No, if you are here, I'll take up at 2:30.
Yes. The only thing is
Because other side should be there. Yes.
only 2:30. So
Finish that.
I finish that and come.
Yes.
But I otherwise ready.
Yes.
Item 23. N. Manohar.
Appearing for respondent, your lordship.
Record.
Last occasion, I attempted to produce the record.
Yes. What the record? When? It could be for 6 weeks time. 1 more week time. So, the record. 14. Stop. 14.
Obliged.
Item 28. B. Krishnamurthy.
Yes.
They filed counter, I also filed reply served on 2/11 itself.
Yes.
Is there is the owner of the land. Case number 25/1/2.
Yes.
Password 250.
Item 29. Damodarity.
This matter, an alternate reserve, and then opened it for to be heard. The first issue with regard to the legal aspect.
They filed additional counter.
Yes, they have filed survey. My last had raised that issue.
This our number I had given on the previous occasion, 10-3-5-7.
That's appearing for board method.
For reply also subsequent time, but that is fine.
Yes. Damodarity.
That's appearing for board method in the matter. That additional counter was filed, Millard was returned. That resubmitted it today, Millard. All in.
Resubmitted, huh?
Yes, Millard, resubmitted.
They say today it is resubmitted.
He was supposed to file a reply.
You said counter affidavit was filed on the last occasion.
Yes, it is accepted. It is accepted. It is accepted on 16/10. 16/10 itself.
It is accepted and council says that it is returned and it is resubmitted today. Mr. Joshi says so.
Yes, Millard.
Pass it over and clarify with him. Because
Farhan appears.
the code website says it's accepted, numbered also. I'll inform you, because he was not available at that time. I believe the job was given.
Yes, Damodarity.
Time was given, 1 month time.
Not filed. 16/10 we granted time.
1 month.
They are passing.
File it. File it. On council for the petition to seek.
Take this number.
Post, when shall I post?
16/10.
16th, huh?
Yes,
On 16th.
I'm obliged.
File section.
Yes, yes.
Item 30, viewing jail.
Already the matter was fully argued.
Let's see what is that.
Issue.
Yes.
With regard to. So.
Reply to the counterpart by the G2 for home. Is also accepted. Friday it is accepted online.
You argue once, you place that Advocate Commissioner report and all on
Yes,
record.
I have asked clear. Along with the employer, place all the commissioners report photograph.
We have it on Monday, next week. Meanwhile, that order, I think that's not dispatched still.
Yes, order is not dispatched.
Not dispatched, so that will dispatch it today. Is appearing for GP for home? Or representation for respondent? Yes. You make submissions. And taking over possession and all that serious allegations are made, and you have not argued the matter in fact in detail.
In fact, the photograph shows that you have been disposed, demolished, everything. Their counter is silent. They say that only this was transaction material was placed and FIR.
Get the matter. Get the matter and then like 14. Yes.
Item 31. Hidden policy.
For the conditional appearance, like that to file a.
Counterfeit.
Yes.
Use for petitioner.
Then file.
What is the matter?
It's an RO bridge, that is an RO bridge, wherein your lordships have disposed of who were allowed to lot satisfied.
Yes, yes.
And others was challenge the liberty has been given. In this below, there are two petitioners and notification has been given 2012. Thereafter, they have purchased the lands in 2013 and 14. In the affidavit itself, they only have stated. That's what we have.
Award pass.
Yes, award has been passed and referred also.
So pass over it.
But I didn't serve the papers on the
Counter.
Yeah, yes.
Let them come.
Yes. And not only this matter, in this batch, another case is pending before your lordships. That
In the
count
list?
is filed.
Listed.
Yes.
In the list.
Today it's not listed.
Yes. No representation for petitioner. Counterfeit. Counterfeit. No representation
That
for
we have
petitioner.
referred. for
Post tomorrow along with WP number.
26367.
Same council.
Yes.
Item 32, demolition.
Just now, this will counter your next.
What is the matter?
Matter of land acquisition that I filed counter just now. I will file a reflect this kind of land in fact. Section number, they are seeing certain land. But they were substituting around the same and the lands were assuming but the recognitions are also parties to the redemption proceeding.
Yes,
I think the tax benefit are
counterfeit. They are looking for the petitioners 6 weeks time for filing reply. 16th finally.
Item 33, MN Narasimha Reddy.
Without before the consideration. It's a conditional appearance, but there was a miscommunication between the two departments. party has been misplaced when this order has been passed, so we couldn't inform to the. It was news and but in this Milord, there is no prayer, neither land acquisition officer is not made a party to initiate land acquisition proceedings is the prayer. Earlier petition also same, keeping the revenue up here.
Acquisition proceedings should be initiated by the RTO concerned. Is the party. Now, RTO is the party. Now, Milord, they admit that, Milord, they have utilized the Milord of Pata land. They report, Milord, they can't improve their, Milord, they are impugned order itself says that, Milord, they have utilized. They're presuming that their lands are being gifted by the petitioner's family for village development. Milord, even now, Milord, their names are reflected in the revenue record.
We are not at all disputing regarding the payment or anything, unless the counter will not, we cannot say anything.
Yes.
Due to our council's mistake, will not have.
Yes, ma'am.
May kindly grant.
Yes, sir. Printed well on digital and acquisition. Because of the communication there. It's just a-
Final orders have been passed.
Elections RDO, they are asking.
That's not, it is not the first time, Milord, finally means the third, the orders have been passed by this one. Giving final chance.
11. No, let it be practical. Otherwise, again, one more, once again, it has to.
They can't improve, Milord, the impugned order.
No, but see, we should, if the counter is there, we can dispose of the matter. Without counter,
They are 2018, they were last match, peruse the docket, Milord, how many?
yes, next.
Item 34, J. Suresh Babu.
Yes.
Implementation of highway proceedings. Always they have filed a DC Milord. Plus the state lands.
Cool. Settle down first. I'll call the next matter, I'll call it. Yes. Immediately after the next matter, I'll take it up. Yes. Next matter.
Item 36.
This matter because the last one directed to file some documents. When I got the document of fact, it was before the election to allotted it only. But I am also filing the counters of the traffic before the giant collector. Where we
Matter item 35.
36.
35 is what?
I'm sorry.
But in this case, I have challenged the ORC issued by
The matter is not called, sir.
36 is showing in that. He called 36 and is showing a 36, my lord.
35.
I'm sorry, my lord.
35 you are not quite fine, but implement petition, not pressing the change.
You are for?
For implement petition.
IA number?
A number 1 of 13 euros. 15937 of 2013.
You are with Ramakrishna.
Yes.
For the petitioner. It's permission to withdraw the this application. A1.1937. The time submitted.
Smart.
Who is for petitioner?
Mr. A. Prabhakar.
But complete order in the
Like in a Indian survey, private land of 10 kuntas was merged with the government land. Against which I filed an issue. Now I have settled with the diverse associate petitioners.
what the petitioners have chosen application. The petitioners have
Only one of
please.
petitions were allotted government land. No, they want.
You are no more now. You already went out of record. Password.
Petition not withdrawn.
President available. Dismiss is not president. Yes. Give function. Yes.
Item 34.
Where the update was explanation of the policy. You applied. Petitioners applied. Yes.
But what I will this was starting the joint started with case number D5 by D4 dated 5/2/2005.
Yes.
Not the land is 33 of Chincha navigation. Not case the Mandal. Our district comprises of 870 acres total. This land, the such land is not subdivided either on the spot or in the map. Though the revenue record that is Pahani shows various subdivisions. Survey number 33/1 is a forest land. The private land is only about 120 acres, 11 guntas, as per village record. Before going to the part, and it's also continuing.
Yes.
Against the LGC Milot on the same property. They find the restriction figure 169/13 and 48,887 of 2013. This application are pending ones before this account.
You filed the requisition.
I filed the request. If they are releasing a then one against us. It's been the 5-year proceedings. India of the transfer problem. Already article conducted the survey and he found that it the entire land is different from other the records claiming the land.
He is appealing for R1.
But urban he made it about it. How is not coming? He found that he made it. And the other two applications are between fictions. The last application is joint touch order for second last 354. These are the conversion of the land from urban, yeah, because the land to urban agglomeration. Highway was at the site. $325.
You made application under 5A.
Yes, sir. Along with the other petitioners.
Who are the other petitioners?
Other petitioners are the tenants, not tenants of the land. 3 to 6 are tenants. Three applications are filed, commonly disposed of.
Yes, read that.
The tenancy page on 31 will occur to get It starts at 30, page of 30.
Page number 31.
30. During the source you have got it.
You want to start at page 26.
Yes, sir. Page 26, page 30.
Yes.
During the course of inquiry, the applicant association filed a copy of layout said to have been issued by Sarpanch Bodukal Gram Panchayat on 7/4/1968, bearing numbers also. Is titled as a layout plan of Vijaypuri near Cherapur railway station. The said layout does not refer to any survey numbers or village. The Secretary of the Society filed a application on 10/10/2023, claiming that survey number 33 of Chenchana village comprises about 1,500 acres, and the said land is not used or divided either on the spot or on the village map. Both the revenue records are Pani Patrics show various subdivisions. He has filed a plan along with the said subdivision, wherein the portion of the minimum is shown in green color is decorated by him as the land in position of M. Venkatreddy and others. That is response number 2, and that it is covered by compound wall on 2 sides and barbed wire on the other side, other 2 sides, and that it is completely plotted and developed with a flat top floors, drainage lines, where the effective plantings, street lights, and electrical transformers, and overhead tanks with 2 bore wells and a watchman quarter. He admits that the set lines of flat is in the position of the response number 2 and others. The further opinion that portion of the show as B in the plan is because the mark as well in the red color in land belonging to the applicant society, and the portion are shown as C. In the plan enclosed and the mark with color yellow is the agricultural land in position of the respondent. Another, and they are in position of the agricultural land carrying agriculture operation and is comprised of farmhouse, open well, underground pipelines, bore well, Goa garden of 15 years, old mango garden, citrus land, 3 fruit trees of 10 years old. It is enclosed by plants on 3 sides and bushes on 1 side. in the same engine position of the environment respondent 1. Therefore, we requested to that the appeal filed by the appellant resolution in respect to the land of respondent 1 and 2 and others is to be dismissed. Similarly, on person by name K. Nagaraja filed another application on 6/11/2023, where he claims his father acquired plot number 159 division. And then it was 525 square yards, who registered in 1960. They forming a part of 7/30/11/33 letter of provincial amendment, and we filed a copy of the outline. They have dated 9/74/1968 map of provincial land showing the land of appellant declaration is around 33. And also a layout of Aravinda family located between the land of respondent 1 and 2. He submitted there is only one vacant land area which is adjacent to the forest land, and according to him, is the land of appellant's assertion. He accused President and Secretary of the appellant association for litigating in unnecessary litigation for the land in the position of the respondent number 1 and 2, respondent 2, and other legally affected the actual area of the land in the association. It is also stated by him the land of the association is different from the land in the position of the respondent. Therefore, we request for getting the land surveyed and demarcated. In view of the above conflicting rights and counter claims, and dispute with regard to the location and identification of the land claimed by the appellant association and the respondents number 33 of Peninsula Village, I have directed the Deputy Inspector of Survey attached to the Division of Office of Letter dated 14/11/2023, meeting number A2/737/2003, to inspect the land survey number, land area survey number 33, and to measure and demarcate by localizing the claim land of the appellant association before respondents, and to submit the factual report along with the sketch. Pursuant to which, the Deputy Inspector of Survey, after completing these directions, submitted his report on 23/11/2023. His report and accompanying sketch localized the properties claimed by the respondents, reflecting the future ever done in his claim counter. The property claimed by the respondent is located on the western side coast of the survey number 33, while the property claimed by the appellant association is located in the extreme eastern side portion of the survey number 33, abutting the forest land. They are found to be distinct and away from each other. The report of the Deputy Inspector of Survey broadly confirmed to the respondent recommendation and sketch filed by the Secretary of the appellant association and the recommendation filed by the Nagaraja. To satisfy myself with regard to the truth of the otherwise of the case of the appellant association, respondent Secretary of the appellant association represented by one Nagaraja and the report of Deputy Inspector of Survey, I have decided to make legal inspection of the land bearing survey number 33, and according to memo dated 6/12/2023, notified the party with a copy of a memo fixing the date inspection as 10/11/2023 at 3 p.m. and directed them to present at the site along with the record. Accordingly, I inspected the suit property on 10/12/2023 and verified the factual position of the ground with the reference to the claim of the parties. During my inspection, I have noticed the location and environment of property claimed by the respondents is located on the western side of portion 33, while the location of the property claimed by the appellant association is located in the eastern side of the portion 33. According to the forest land claimed by the both the parties are not only distinct and separate, but they are away from each other. All the physical features in copy of the report, Deputy Inspector of Survey and location of land and the party has for sketch and close to the report are found to be true and correct. Moreover, because reported not available, but respond filed copies of the existing orders. For the above information, clear that the land claimed by the appellant association is located in the eastern side coast of the survey number 33 of Peninsula Village. Land claimed by the respondent is located on the western side coast of 30. The respondents are claiming the land in their occupation on the western side, the same is for the into north and north. Therefore, the into north pertains to land claimed by the appellant association. As the appellant association is located as a land affected by the into north and north. This is the order for the RTO. The above findings are verified. Based on that, they are applied for joint venture. Joint venture case now in urban land from the attached urban land in India, and the pilot does not happen.
Where he said that?
Page number 25. The page of military options.
Yes.
Finally, pursue the material papers place before the court and you also verified since the land in question was converted for use from agriculture non-agricultural purpose. The published record by joint Hyderabad district exchange for which also reflected in the second registered changes and by the original owners in favor of the property purchase. The below plan was also sanctioned by Sarpanch, go to Gram Panchayat. Authority is also seen that as per GYMS also, 33/8 is and 33/2 are actually fallen under urban examination of sense. And again, 33/1 and 33/2 and 33/7 are partly falling under other rules. As per rule 9 of the unauthorized rights and the Affairs of Act, Rule 19 no order shall be passed for a change of registry unless the recording authority, Mandal revenue officer is satisfied that change of registry is not conversion of the province land reforms act 1920 or urban land ceiling. For the instance, case the land in question affects the urban land ceiling act 1920 and is not within the extended power of the Mandal revenue officer. Again, upon the Mandal revenue officer has given the ambit of the execution and the Mandal revenue officer also asset. And gives a finding that in the 25 this order was the challenge. Our condition is that wherever there is a subdivisions are there under section on paper, not on the building. I think the report copy also not changed the copy select.
Pardon?
Report also. But basically on this order, not they are NBC as they are not doing the one of NBC. Because we have to transfer order. And the restrictions are pending.
LGC decided by
And that report.
what is that number?
This is the in the
WP number.
16962 of 2013 and 288 of 7 7 of 2013.
They are pending.
Yes.
Commission for the petition for correction. Scopes of review, but it is appropriate. Say this reflection along with the booking numbers. In 6 months, the billing is settled from the this is matter along. So we'll post it along with the other.
Stop that now, we lost me inside of it.
Councils are not here.
They are filed last two occasions they are not
Two occasions you took time, not they.
Last things 2 times they are
Let it go along with that would be better. Yes.
Item 36, P.R. Manohar.
Some documents. My request is I should clear time. It came posted Friday, not all the documents because the person was in charge of all the documents was totally seriously clear. And yesterday he came to my office and he counted before the giant collector everything I am submitting. They are not accepted anywhere. That it is a better service. It has to be decided by the collector. Collector counter also made a proceeding. He was saying that it is a denominator. Friday.
Yes,
my lords, but this is Writ petition is challenging the issuance of ORC in favor of so and so. Joint court clearly says it is a conditional service. But I read that your lordship read the joint collector's order, impugned order. Both are agreed. Where is the question of saying somebody is there, some document is there, and everything? Your lordship can see the impugned order, my lord.
And also satisfied with the judgment also, section
No,
4.
my lord.
Everything, 17 firstly, 1320 firstly, where the Mutakab was.
Whatever it is there, my lord, your lordship can see at page
If he is entitled for the ORC or not.
page 20, my lord.
That's about the limitations of the repetition.
Page 20, my lord. Your lordship can see page 20 of the writ petition.
Yes.
Issue number 1. The counsel for the petitioner and the counsel for the respondent both have accepted the suit lands are inland lands burdened with service. When it is this so,
Friday finally.
after the capture of dismissal.
Yes.
Item 37.
As a partnered will lordship.
Give English.
Respondents taking any proceedings regularizing our position matter for both fathers displaced from the Pata land. The purpose of dumping garbage by the then municipality matter. In 75, it is a correspondence stage. 1942, they displaced matter for the purpose of dumping the garbage of the municipality. And we are permitted to occupy the government land in survey number 308 and 303 constructed houses and they were cultivated this environment. The 308 matter. Earlier on, we tried this honorable court directed matter. It could not taken any.
What is the extent of land you are claiming and
Allot 4 acres matter.
where you said that? Prayer doesn't refer to that. You simply say 2 survey numbers. Anyway, Andrew, which law you are entitled for ownership rights?
My lord, we are displaced from the land, my lord. Correspondence since 75 and admitted.
What is the correspondence available?
Page 24, my lord. Then collect. This is dated 26/8/81.
Survey number 261 also government land.
Survey number 261 is Pata land, my lord. One, as far as Pomeroy was the Pata, our forefathers purchased this same under full same deed. And 42 they directed us to vacate the same, my lord, for the purpose of garbage, dumping garbage, and we were permitted to occupy survey number 303. Since 1942, our forefathers were in position, my lord, in 64, 65, Pani entries also, our position is there, my lord, revenue records also.
Is there any proceeding authorizing you to occupy that land?
No, my lord, it is not there, my lord. Our names were entered in the revenue records. Position column. I got 64, 65 Pani. The correspondence is there.
These for house sites?
Now, since the property is included in the municipality, we are not entitled for cultivation, my lord, only for the purpose of house sites. That is the letter addressed by the collector. This page 14, my lord. Page 14. Dated 31/7/2000.
Yes, GP garu.
Even this also not implemented.
Now what comes on Hamikonda district?
Yes, part, Makoda. Earlier on, they produced the record mallet.
What order you expect now?
It is regularize our position mallet.
Under which scheme, which law?
But then
Is there anything to show that you are displaced from other survey number and you are asked to occupy this land?
that was 1942 mallet proceed. Correspondence is there, mallet is obtained from that. They are starting under right to information. Earlier round also they produced the record mallet.
You are in occupation of the land.
Yes, mallet.
What is there to show that you are in position? Page 12 or page 14?
Yes, mallet.
You are in position of this extents or you are
Position of this extension.
Where is your name in this?
Mallet, Kotla Jan, 8 mallet. Father.
So you are only claiming through the Jan only.
Yes. Is our grandfather.
Counter not filed. And no orders are passed pursuant to this.
They are not at fault.
So I dispose of directing the collector to public orders. First time అడుగుతారు మళ్ళీ అదే కదా.
Monday was that.
I'll dispose of them.
38 and 39. B. Rakesh.
Respondents 15 to 17 and 18 to 24.
Yes. What is the matter?
Issues of ORC in respect of non-persons.
There's a cancellation of the ORC's issue to these respondents where they were not a party to the ORC proceedings also. These petitions were not a party to the ORC proceedings.
Thereafter, they execute a GPA.
Is on the date of vesting your lordship, no rights were actually except one right to claim for the rights. But it has the RTO considering all the allowed partitions and that too amongst to section 4 of the Act law, wherein the section does not allow lands to be belongs to community. He says that they belong to community and allow them to partition the law. No rights were accrue on them to do the partition. That's only right they have is to pick off the vesting lordship. Whereas the unpinned order, based on the rights, it's passed here. But no rights exist. And the respondent are allowed to.
This is under the Enhanced Abolition Act.
Yes, sir.
Let's see the order of the RDO.
In 6840 of 2017, the RTO order is at page number 23.
Page 26.
WP number 6840. 7.
Then what is the other petition?
That is
Connected
petition.
Connected in what way?
There are different proceedings, but arising out of Enam Abolition Act, granting of ORCs.
How they are connected? The subject land is same or
The subject is same. Cover number 395.
order impugned is same?
Yes, sir. My rights are effective also because my vendor are supposed to get the ORC. But the RDO, before looking into the not complying with section 10, your option be passed in that.
Did your vendor made any claim for ORC?
Yes, Lordship, he made a claim, Your Lordship.
What happened to his claim?
Initially, when the claim was made, there was some contention, and subsequently.
What happened to his claim?
What he said is what he allowed exchange the rights claimed under the surveillance.
He claimed under the same, decided in the same proceeding?
Yes, sir.
Decided by the RDO.
Yes, sir. So there is no concept of exchange. I cannot say that I don't have rights to give the rights to somebody else. So that only has to give it to RDO. Wherein the RDO allowed my rights to be extended with the respondent. Your Lordship, and page number 40, Your Lordship. The pair number, Your Lordship, second last paragraph. Coming to the individual claim, petition condition that they are the grandsons of Thinker, who is the original owner of the land, and they alone identify grant of force rights here, okay? And the relief, the entries of power is so and so, and since the grandfather is in position of the land, Your Lordship, they cited one judgment, Your Lordship, wherein it says on the date they should have some kind of right here. On the date of the vesting of the lands in the state, being the elder of the community is not. Once they use the concept of community, that's hit by section 4, Your Lordship, wherein the act, Your Lordship,
What is this exercise by RDO?
Get instructions.
What is this? You want to get instructions from RDO? I think
Act 4, Act, section 4 says
registration of Yandras occupant. Every shall with effect from so and so date of vesting be entitled for so and so other than lands set apart for the village community. The word once community is inserted in lordship, read by the section 4. Basically, it is not compared to section 10. You are not correct in time is 40 pages. They say, however, during the course of inquiry, so and so file the affidavit relinquishing their rights. There is no rights, there is no concept of relinquishing rights. Unless until the advo grants the rights, then the concept of selling, relinquishing, partition comes into picture.
You have to prepare some brief note on these facts.
Lordship,
How can you argue saying something and without saying anything about facts of the case? Nothing. How do you expect the court to appreciate?
Next day.
Who are the persons in whose favor what is granted? They are the successors of Inamdar or?
No, sir, Your Lordship, they are not suicide. They claim that they are, they have to communicate.
No, their claim is that page 22. The claimants are the grandson and granddaughter of the original Inamdars. The claimants, along with their petition, have filed the following documents.
The response are nowhere connected with the.
Sir, what do you say on this? The audio order says so. If you don't argue the matter by preparing well, I'll find one reason or the other and dismiss the petition. It's very easy to dismiss.
Page number 22, Your Lordship, requisition 68%.
You purchased from whom?
Lordship, the GP holder of the original.
Who is your vendor, sir?
Vendor is Lordship R3 Lordship, in the Ricky Lordship.
Yadagiri.
Yes, sir. Who was the GP holder for R4? Who is the original?
Your vendor is granted ORC.
Lordship, my vendor is not granted with respect of 395 subsidy. He sells, he gives the rights of in respect of Sabino with respect to R4 Lordship. Subsequently, he says that I don't, I'm relinquishing my rights in respect of that's the reason I'm claiming by the third person as filed this.
And you purchased prior to grant of ORC.
Yes, Lord.
Then what is your right? How?
I am not asking any business to grant of only awards because my rights are getting affected. And the awards is granted in favor of the my vendor. My vendor says that I am relinquishing my rights in respect of survey number, in which he already sold all the land share. Through R3. And even R3 also filed a requisition before the salt clerkship and obtained interim stay also. Subsequently withdraws the requisition.
Where is your sale deed?
Joseph, 42 onwards here.
Yadagiri is only GPA holder.
Yes, Lord.
You said Yadagiri is the GPA holder of R4.
R4.
R4 is party to this sale deed.
Not shaded together because he sold through the GPU.
Through GPA holder అయితే GPA holder sale vendor గా ఉంటాడా ప్రిన్సిపల్ ఉంటాడా?
Worship, it's a GPA comes interior worship.
ఏది GPA కమ్ సేల్ డీడ్ అండి? Ultimately, what you have purchased is only house property.
Yes, Lord. Plots.
Where they say he said that he is relinquishing his rights.
Sure.
You have purchased from the property from
GPA of R4.
GPA and అసలు you don't know the basic things, don't say all that. Who are your vendors?
My vendor is R4, R3.
Show me from your sale deed.
Your Worship, kindly see WP number 9593 other
ఇందులో చూపించండి, ఇందులో
number 63 in that year.
6840 లేదా?
Worship, page number 54 year.
Yes.
53 year Worship, vendors so and so are represented by this registered.
Who is vendor then? Who is vendor, sir? Vendors are represented by GPA holder.
Yes, Lord.
So GPA holder cannot be a vendor.
Worship, 44 year Worship.
చూడండి, చూసి రండి. Unprepared to answer. Yes.
Item 14.
4 weeks is
Item 41, B. Pochaya.
No, please, Milord. Milord, it was adjourned on the ground that to get inspections, Milord. Milord, the land was not acquired. That's what the country also says. But Milord, the debris were dumped in the petitioner's land, and also made a small road to approach the open cast land. That's how they are encroaching the land, Milord. They dumped the material in the.
Any reply file?
Not accepted.
ఏం చేయాలి చెప్పండి.
Milord, adjourn it, Milord. I will file photographs also, Milord, and reply also, Milord, for the counter. 1 week or 2 weeks.
Request of council for the petition is supposed to be released for the meeting.
Yes. Item 42, B. Shivkumar.
2 weeks.
Pharmaceutical.
Possible.
Item 43 and 44, P. Venkatraman.
These matters for complaints of the ex-serviceman matter.
Yes, what happened? Any development? మీ ఇంప్లీట్ పెట్టాలి కదా, మీ ఇంప్లీట్ పెట్టిన తర్వాత చూద్దాం.
Complaints there yesterday, they tomorrow informed me that they are approaching the collector. Please requested.
Yes, sir. It is represented by C.H. Venkatraman, Land Council for the petitioner, that the respondent Tahsildar is pursuing the matter with the 45 concerned district collector, and matter may be adjourned for some by 4 weeks. For the matter from 8th December.
I request my infield petition.
చూద్దాంలేండి అప్పుడు.
My request, I filed along with the documents that 44/1 attached the property to the assets of the infield petitioners.
Yes.
Other parties, whenever this honorable court earlier direction, they
Let collector take decision first, then they will, that is ultimately to your interest, then we'll consider your input.
Item 46, Amol Abdul Karim.
Right, the election is on 18th.
Is for petitioner.
Notification is the second sheet.
Yes. Emphasis by the original violation of the above password is stored in everything in the 560.7. During this court direction on behalf of the constitution. In terms of regulation 5, regulation is 2009. Of the institution within a period of 3 months. But today, when the matter is taken for consideration, there is no representation for petition. The above from land appearing for response. The process of constituting managing committee is already commenced, and the memo was issued by the F member, so and so date 18/10/2023. Duly fixing the date for conducting election on election, and the same is scheduled to 18/11/2023. If the council also stated that The election would be conducted on 18/11/2023 and the managing committee would be constituted immediately thereafter. In the later phase of we are not finding a reason to contempt proceedings against the respondents. The same is accordingly goes to directing the respondents to see that proper managing committee is constituted. The election that is scheduled to take place on 18/11/20. Yes.
Item 47 to 54.
Regarding singering, where RLR amounts are differentially calculated, and sides are not being shown. On the last occasion, Sanjeev came requested time to obtain instructions regarding the allotment of plots from singering. That's like it should like that. We should adjourn for this.
Yes, who appears? Yes, also. Up to 51.
Yes,
54.
Yes.
Small body mention. Change.
Yes.
50, 50, your lordship, 50, 51, 53 also, your lordship.
Yes. We're in position now.
Nobody is in position, is open plot.
Petitioner claims that also clearly they for the 158. But 150 given some enclosure further where we admit that demolition of structures in survey number 157, which is government, not BEA. Allotted to the reallotment to the enclosure from third party. But petitioners were never constructed in 157, not only claim for the compensation. For enclosures in 157, we demolished.
Statement the final have demolished the house lordship containing 3 mulgis and 1 shutter lordship. It is was built up in an old structure lordship. Some part of the structure is in old structure. They have
their affidavit also filed in the movement.
The count also they admitted lordship. They are stating that it is in 157 lordship. Whereas the constructor set out in 158 lordship. They have demolished illegally lordship without giving any notice and opportunity lordship. The petition is eligible for compensation lordship as per the LA Act. Even the
Compensation for what?
loss sustained by king lordship, they are not brought any ordinary land lordship. It was incurred huge amounts lordship. All the retirement amounts it was spended to build up that.
That all right. How can you expect a payment of order for payment of compensation in a repetition?
So for illegal demolition by my place, so my house is
Conditional subject to allotment of alternate inlet, we demolish the encroachment. We fulfill the alternative allotment.
Any reply filed?
FAOC is filed.
I 41 December, I'm sorry, I should end in until matters may be taking up to 2 weeks here also. Meanwhile, we'll get the instructions because the lands which were allotted to the, but they have not received the information from the single.
You don't get unless appearance is ordered, you don't get.
Next week, your lordship.
Sufficient time is granted.
Next week, your lordship, we met.
Passover, if you don't get a, if you don't respond and I will issue Form 1.
Next week, your lordship, meanwhile, we'll do it.
25 plan. The order of this court is complete.
Yes, madam. How much compensation?
As per the LA Act, as per the market value.
How they will assess under the LA Act, not for the land?
The land, it's the land as well as they have not provided the alternative land worship. They have not.
Why should they provide you alternative land? They say they did it everything in one survey number 157.
Lordship, as per the sale deed 158, I raised a structural lordship, 3 multis and 1 residential quarters. In view of my absence, they have demolished illegally lordship. That is my condition, lordship.
They say they have demolished in survey number 157, not in 158.
Lordship, whereas that 3 multis and 1 residential quarters belong to the petitioner, lordship. Lordship, kindly see the page number 13 for the lordship.
Page number?
Page number 13, the petitioner was given a police complaint on the instruction received from the neighbor's lordship.
I'll leave it open to you to take claim damages against them. With petition, how can we grant compensation?
I will amend the prayer, lordship, with regard to
Changes are amended, say what you propose to amend. What is the proposed amendment?
lordship for raising the structure, he has incurred claim to 6 lakhs. All his deductible amounts he has spent, he has registered construction, lordship.
$230 matters. Item 24 and 25. Please have it more.
Same order in the as in the batch. For want of complying with 16 to 18.
All these 4 matters, there are basically two notifications, 24 and 25 pertain to one notification.
Yes, yes.
The issue is they have lapsed. There's no gazette notification. That's the main issue. What is all the underground circular?
But that will cover the directions issued in the batch.
If your lordship is shifting
the date of notification will
that observation, so there's no gazette notification produced.
but that will cover the any appeal filed against that. Government also has one. Same order will serve the purpose.
My only worry is that would be fine. Only worry it should not be construed as the court agreeing with that. There's no remarks on that. That's will have to open, will not super.
Yes, yes.
I may make small correction. Yes, regarding item 24.
Yes.
Declaration gazette. The problem with lordship, the authorities did not provide copy of that. So, and they provide wrong information in the award. Gazette number they wrongly stated of the declaration.
Award is being set aside now. No problem. Award and 19 are set aside and permitting them to proceed from the stage of considering the objections.
Calling for objections in the date may be shifted.
Yes, yes, notification is on.
26 and 27.
Yes.
Passed all matters.
Most of the other matters also will dispose of in the same lines.
Most of them.
We list them.
Only in specific cases, 11 is invalid. Other cases, it's similar.
Yes.
That's okay.
Item 7. Yogi Prasad Kumar.
Pardon? No, they are ready in the morning because you nobody is there for respondents. No. Morning he wanted.
They are taking time. I'm not requesting time. If they are ready.
So you today you want to request, huh?
Short date maybe.
Why? Why short date? 2006 matter. And now today onwards, all special identified matters, whoever asks time per day 1,000 rupees cost. Either petitioner or respondent, whatever it is. Not next time. We already today we have imposed costs on 2 matters. How many days you want?
Last occasion, they have taken time loss. 3 times they are taking time loss. Senior counsel is appearing in this matter loss. If they are ready.
They are ready. That's what he, in fact, Mr. Suresh Kumar is here in the morning because nobody is there for respondents. It was passed over. No. Nobody represented. I asked who is appearing for respondents also. Yes, let him come.
Item 14. Where number?
Yes.
The petitioner has been assigned land in the year 1992 to an assignment pattern. As the husband was encountered due to extremist action.
Yes.
And subsequent to that, in the year 1997, her patta was cancelled by respondent number 2.
Yes.
In fact, it's a similar not passed in a similarly placed situated.
Please complete the facts. That's all the facts?
No,
yes.
Subsequent to that, the patta was cancelled on in the year 1997. The fact of the cancellation of patta was never known to the petitioner herein till the year 2003. 2003, when the petitioner herein had requested the respondents to issue title deeds and patta passbooks, they have passed a memo in the year 2003. It's annexed here in number 18. Lordship, may kindly have a look at page number 18.
Yes.
This is the memo passed by the respondent number 3 minutes referring to the cancellation pattern.
Yes.
It says with reference to the application so and so, the petitioner, it is informed that the application is forwarded to Maru Karnagar so and so for taking necessary action for allotment of agricultural land as per normal rules of assignment. However, government issued instructions not to assign agricultural land with a radius of 25 kilometers from Karnagar Municipal Corporation. Hence, your request is not considered. This was pursuant to our request minutes. The subsequently minutes, what had happened was the petitioner here in minutes had approached the respondents here and then saying that minutes the patta cannot be cancelled for two on
No, this is not cancellation. This is refusal to assign.
Cancel.
Cancellation.
Well, page number 16.
18 you read now.
Yes, yes. Page number 16 minutes. 16 is in Telugu minutes, 17 is the translation portion of the English. It says subject to public service center issuing particular passbook and affiliate to survey number so and so, 1 acre 20 meters of government land, Shikam at Gomkal village, Karnataka Mandal, Karnataka district. It's referred to my application and everything else. This is to inform that the petitioner emails regarding the opposite contents. The MRO observer number 2 has conducted the inquiry, and in that inquiry, we came to know that the assignment land which was allotted is the Gram Katam land, Shikam. Hence, it cannot allot to private persons. At the same time, as per revenue records, this land, so and so dated 25/1/1992, the land in survey number so and so was assigned to you. But as per RTO, Karnataka letter so and so dated 1997, it is declared that this patta was allotted to you on illegal way and cancel the patta by revenue authorities. Hence, we cannot grant you the pattadar passbook and title deed on this land. Hence, this information. Subsequent to this, multiple representations will be.
Where is the cancellation proceeding?
That's we have filed an IAM with respect to the minutes. 1997 proceedings minutes were not given to the petitioner minutes. We have requested for experience with petition minutes. However, minutes we agreed with the memo as well. 2003 memo also we agreed with for the 2 reasons. The first reason is this minutes under section 166B.
No, you are questioning that 9/7/1997 proceeding. That is not on record.
That's not on record.
How can we decide validity of that? How can we decide validity of a proceeding which is not before this court?
Because in fact, the state proceeding is referred in the memo minutes.
సరిపోతుందండి అది.
Whereas in fact, from my instructions minutes in the last occasion also, other side was requested to get this proceeding before your lodge minutes. However, that wasn't done minutes. Minutes, also in the last occasion, they are published.
What is the other right petition?
Minutes, the other petition number is minutes, WC number 20870 of 1995.
What happened to the petition?
That in the petition, alternate land was given to the petitioners there in Millets. In fact, the facts are very similar Millets. They have also been assigned patta land.
Where is that order in the petition?
Millets, in the last occasion, we furnished this copy which has all the documents. Is that I have got another copy, extra copy for that list.
Issued order therein also same proceeding
Yes, Millets. There
or
also
similar proceeding?
similar proceeding. There also patta was cancelled. Millets. The order says like this. Millets.
Proceeding number is same.
No, Millets. The proceeding number is actually different. Millets.
The petition is same.
No, Millets. Here, the proceeding number is
Yes.
Millets. In my case, the proceeding
962 699.
6992 minutes. In the other one,
Yes.
it's 699. It's 6992 minutes. Six nine six two minutes. In the other proceeding, it's 6962 minutes. In my case, it's 6992 minutes.
Yes.
Yes, minutes. Minutes. In this order, the grievance is the same minutes. Your lordships may kindly have a look at the last page. Last before the page number 1 minute. Last 5 lines, Mary minutes.
What which page?
The last, this page is document minutes. In the last page, there is an order minute.
Yes.
Yes. I'll just clear out the order minutes. This petition has been instituted calling in question the orders passed by the RDO of Karnataka Division, Karnataka of 9 July 1997, cancelling the assignment land of an extent of 1 acre 20 guntas in sub number 96 at Bombakal village, Karnataka district, made in favor of the writ petitioners on the ground that the land is a Shikam land and that in view of policy decision, the Tanbed Korumbuk land should not be assigned. The case of the writ petitioners is that both of them have been assigned land in question as long back as 25th January 1982, and they were also put in possession of the land. The essential reason for assigning this land in favor of the petitioners was that their respective husbands, who worked as police constables, were done to death by extremists, and therefore the state government, as a policy measure to rehabilitate the dependents of the victims of extremist violence, assigned these lands. Since there was an apparent conflict of interest between two policy decisions, one coming in the way of assigning Tanbed Korumbuk land and the other requiring the assignment to be made in favor of the victims of the extremist violence, the respondents, in particular the district director Karnataka, on previous occasion was suggested to reconsider the entire matter. The learned government leader had used his good offices in this regard, and he is also stated at the bar that the Mandal Revenue Officer Tehsildar.
But they are already reassigned, sir. Why are you reading that?
Yes, they were already, and copy of Pattas were also handed over to them.
And what is this notice issued to you?
Well, it's at page number 15 minutes.
In the papers given by you, there is a notice issued to your client.
Yes, Melons.
Proposing to cancel that assignment.
Yes, Melons. Melons, in fact, we were placed at serial number 1 minutes. 2 and 3 are the petitions and other petitions who were granted.
If it is already cancelled, where is the question of issuing notice now?
Melons, this notice was issued for stating that irregular assignment took place in so and so, request for cancellation of irregular assignment.
That was already cancelled.
This was subsequent 22/10/2020. In fact, subsequent to this notice also, we have brought to the notice of the respondents about the entry order passed by this honorable court. In fact, in spite of the fact, they have removed our name from the 1B. 1B minutes, 1B proceedings.
Kadandi, Shoka's notice was issued in 2020.
Yes, Melons.
If your assignment was already cancelled in 1997, where is the question of issuing this notice now? And what happened after this Shoka's notice?
After this Shoka's notice, we have furnished a detailed explanation, sir. Nothing has happened.
You have any instructions from your client?
Melons, that was the reason why, sir.
How many times you want time for that? When it matter came up earlier? Because client is not in touch with you means and she was already assigned another land. From October 22 onwards, this matter is coming up.
Yes, sir. I am aware.
And after the matter is listed before this court also, it was adjourned. From 1710 matter was listed. On your request, it was adjourned.
So last minute instance, I just get in touch with my clients and I'll get back to you.
I'll dismiss it for default. And if anything survives, then you file an application.
Melons can also. So that's why I just have this matter tomorrow.
1,000 rupees.
Day after tomorrow, you'll also. Melons can have it.
See,
Melons can have it tomorrow.
nothing you are able to answer, nothing. And why Shoka's notice was issued, what happened pursuant to that, nothing you have.
Well, the situation is like this, Melons. Not.
What they say in the counter?
Let's counter. Counter, they say that the Pata was.
Did they say anything about the Shoka's notice?
Nothing, Melons.
There is being non-local and not standing in the litigation. As such notice was posted on the Gram Panchayat. Petitioner has not filed any objection to that.
Melons, there is no date also, Melons, which is mentioned here. This was the notice which was subsequent to the cancellation of Pata Minister. Before cancellation Pata, that is prior to 1997 is what my learned friend is referring to.
That notice had not been referred.
However, the notice which your lordships have dispatched minutes is not mentioned in the counter minutes.
What is the assignment made to you?
Assignment was made in the year 1992.
Did they say under which quota and all that?
Yes, sir. Your lordship can have a look at page number 12. Page number 30 and the two transactions.
They say project affected lands. Not because of extremist violence and all that.
Minutes, that fact was admitted in the counter of the respondents' minutes, wherein they have said that I'll leave my lordship to the counter.
It's in the police.
Yes, madam. Minutes, para 5 minutes of the counter of the bill. In reply to the amendments stated para 3, in the petitions of it is submitted so and so. The fact that the husband of the petitioner worked in police department, expired during police encounter, on request made by the petitioner, other than MRO, Mandal issued provisional certificate, provisional assignment Pata certificate for 1 acre 20 guntas of Shikam land in survey number 96 situated at Pomukal village. Subsequent to that, they say it's irregular, illegal, without following due process of promises.
Yes, sir. 2 of you. I'll set aside this and I'll direct the Tahsildar, the respondents to consider for allotting an alternative land.
Yes, that's good.
Has not been filed any objection to the your lordship, and he is not deciding.
Yeah, on your own saying you have pasted it somewhere. Now notice is not served also. Yes.
His place in the village your lordship, and moreover the petitioner is not residing in the village.
See, you are not disputing her eligibility for assignment. You cancel it on the ground, it is a Sikkim land, it is prohibited from assignment. And if that is the case, and our case should be considered. And for others, and you already assigned alternate land.
Sorry,
Yes.
like, incorrect,
Yes.
couldn't get in touch.
Yes.
Item 15.
Already assigned. It's already assigned. Yes. You are also for petitioner. Contempt, sir. What happened?
Trying to get information given it's not available because they are not willing to take the money given in lieu of applause. That has been fixed at 3,25,000. They have no vested right, but I wanted to get verified whether if there is any plots are available, then we'll provide. Otherwise, I'll make my submissions on merits of the case after 1 week or 2 weeks.
Amount paid, huh?
Amount is ready, they are not willing to take. Now let the compensation together with this plot amount is lying with us. And if they want to take the money, apart from this plot money, that is 3,55,000, we are willing to pay.
If they deduct the plot amount and
We'll
give
pay.
the remaining amount, we'll take minutes. But the subject to lot's final orders, that plot
What is your stand? Are you entitled as a matter of right for
as a
plot?
matter of right. You 68.
255 minute claimant. Only 3 members were given plots.
No, my lord, that's not.
But time is granted only for that purpose on the earlier
We
occasion.
have written to them. Let the security colorist has to identify and tell you.
It's a matter of right.
1 week or 10 days period, I'll.
No, if they are not responding, we'll issue Form 1 and then.
I myself say that a form 1 will be issued.
Yes.
But that may be made on the next day time.
Yes, sir.
Amount may be meanwhile.
Special government leader. It is submitted by A. Sanjeev Kitlan, government leader. The respondents are ready to pay the compensation amount or not? Compensation amount. Monetary.
Very much. Those 68 is very clear.
You consider on that.
That's a month batch.
Batch.
See, yeah, it was because before the TC.
Yes.
Very much.
Wait, please. The proceedings, individual proceedings, for taking names of the contesting respondents. Followed in the revenue records, is that a challenge in the present litigation. So the individual proceedings followed are at page 70.
Who is appearing for respondents?
I'm appearing for one of the respondents, respondent number 3.
Respondent number please, Tahsildar.
No, respondent.
He's appearing for R5, I believe.
R5.
Yes.
Yes.
But the petitioners, the owners of about
3.36, 3 acres 36 quintals of 764 and acres 5.02 quintals in survey number 65, totaling about 8.38 quintals of Palmakor village of Shamshabad. Look, they have purchased this land, my lord, from the vendors who in turn have purchased from the LRs of the original people. Lord, the details of the transactions, my lord, are given at page 9 of the affidavit.
Yes.
Lord, if my lords look at the table,
Yes.
Lord, the vendors are the LRs of the original PT. Lord, this was in 2001. I filed all these sale deeds. Lord, and then, my lord, the passbooks, my lord, which were issued to the purchasers. They have also filed all these copies.
Yes.
Lord, my draw my lord's attention to the passbook at page 39, my lord. First passbook which is referred to it. I'll not, my lord, take much of my lord's time. Page 39.
No, this page 9, all the sale deeds are in favor of your vendors.
My lord, page 9, all the sale deeds are in favor of my vendor. DB Agarwal is my vendor, my lord.
Yes.
My vendor's vendor. Subsequently, my lord, at page 10,
Yes.
my lord, DB Agarwal has sold it to one Mr. Adil Ahmad. Adil Ahmad has also, my lord, purchased certain property directly from the LRs of the, my lord, original PT. From there, my lord, it was transferred to the petitioners. My lord, all the, my lord, starting from MB Krishnaya, that's about, my lord, petitioner's name shown.
2002 onwards.
2002 onwards.
Yes.
But in turn, my lord, the petitioners were also issued passbooks. My lord, I have shown the passbooks wherever they are available and the link documents.
Yes.
My lord, at page 246, the proceedings, my lord, incorporating the names of the petitioners, my lord, in the revenue records.
260?
246, my lord. The first proceeding is at page 246.
Yes.
So I'll start from 242 onwards, my lord.
That is in favor of your vendor.
My lord, he is also a petitioner to, my lord, to certain portion of the land, my lord, he is still a petitioner. He has retained certain portion of the land.
Yes.
242. And then, my lord, my lords may kindly turn to 248. My lord, is in favor of the petitioners.
Yes.
And then the sale deeds, my lord, will start from 254. I'm sorry, my lord, the passbooks will start from 254.
Yes.
By 2002, my lord, effectively, my lord, the petitioners.
248 proceeding covers the total extent.
248 proceedings, yes, ma'am. My lords, look at the schedule.
Yes.
Well, this was the case. My lord, the unofficial respondents, my lord, started interfering with our position over the land. Then, my lord, we came to know that was in the year 2010 that the impure proceedings, my lord, which are at page 90, page 70.
Yes.
My lord, were passed by the Tahsildar Shamshabad on 12/1/2010 behind our back. Wherein, my lord,
17, huh? Page 17.
Page 17.
Yes.
Wherein, my lord, the names of the contesting respondents were incorporated in respect of this land.
Yes.
May I read this order, my lord?
So pursuant to this page, proceeding at page 248.
Yes, sir.
Petitioners' names were incorporated in the revenue records.
Yes, my lord.
Or only a proceeding is issued?
No, they were incorporated.
Any
They
Pahan
were
is filed?
incorporated because, my lord, after, my lord, 12/1/2010, on inquiry, I came to know, my lord, there were certain orders which were passed, my lord, at the behest of the vendors of the contesting respondents. My lord, those orders, my lord, are at page 12 onwards.
No, this 248 proceeding was issued in favor of your clients.
Yes, my lord.
Your names were entered in the revenue record.
Yes, yes.
Passbook?
Passbooks were issued.
Where are the passbooks?
254 is one such passbook. KV Prasad Reddy, my lord, 254. So let's look at survey number 64 and 65.
Does it refer to this proceeding?
Lord, yes, my lord, at the right hand side, 15, they refer to the 15/5 proceeding. This is 15/5 proceedings. 15/5/2003. The typed copy is wrongly typed, my lord, but page 248, my lords my lords will get the date 15/5/2003. The passbook referred to 15/5/2003. And then in respect of the my lord, page 260, my lord, is the other passbook. Page 260.
Page 17 covers the extent covered by the 248 proceeding also.
Page, yes, sir. Page 17 covers.
Succession they granted.
No, it's not succession. No, there's no dispute with regard to the facts, my lord, that petitioners' names were incorporated in the revenue records. But in 2007, it so happened, my lord, that this I came to know only after these proceedings were issued in 2010. That, my lord, a dispute was raised by, my lord, the vendors of the contested respondents, saying that, my lord, they are the original LRs of they are the LRs of the original PT, and the names of the vendors of the petitioners were wrongly, my lord, shown in the revenue records. My lord, that order, my lord, is at page 277.
Yes.
277. My lords, look at the parties, my lord, it's between the vendors of the contesting respondents and the LRs of the original PT.
Yes.
Lord, the third paragraph, may I read, my lord? Lord, I'll read from the beginning. This is an appeal filed under so and so of EP records and land and Patata Passports of 1971, amended aggrieved against the wrong entries of for the year 1990-91 onwards by the MRO Shamshabad in respect of land bearing survey number 64, admission 3.36 meters, and survey number 65A, admission 5.02 meters, situated at so on Shamshabad matter. The appellants have stated that the land under appeal or protected tenant lands and tenancy certificate has been granted in favor of B.K. Lamada, son of Sakku. And is in physical possession and enjoyment for the said land and died long back and survived by petitioners, herein as LRs and Takutas and become owners and holders of subject land. The appellant submitted after the death of V.K. Lambada, the authorities have written the names of respondents wrongly in the Pahanis, 1980-81, instead of this appellant. The respondents are in possession of the subject lands and request to incorporate their names, deleting the name. Look, this is the issue. Then, my lord, the order at page 278, the next page.
Yes. Yes.
Lord, the penultimate parameter. Accordingly, wrong entry is made. Lord, if my lords look at page 278 for respondents, none appeared.
Yes.
Because my lord, no notice was issued. And then at 279, accordingly, wrong entries made against survey number so and so of so and so village is in appeal is hereby set aside and remanded to the MRO for disposal of issuing notices to all concerned. Entries were deleted, my lord, directed to be deleted, and the MRO was directed to, my lord, inquire, cause, my lord, an inquiry by issuing notices to all the concerned.
Yes.
Then, my lord, take action, further action.
Yes.
My lord, the MRO's order, my lord, is at page 280. The 281, my lords, kindly turn to page 281. This again, my lord, is dated 18 to 2008. That is, my lord, after my lord, my names, the petitioners' names were incorporated in the revenue records, 2002, and passbooks were issued in my file. And my lord, no notices again were issued to me. My lord, at page 281.
Yes.
During the third paragraph, during the local inquiry,
yes,
both the parties claim that they are the successors of the protected tenant V.K. Lambada. The petitioners claim that the protected tenant V.K. Lambada is son of Sakru, while the respondents claim that the protected tenant V.K. Lambada is son of Jaya. But on verification of the tenancy records and the 38E certificate, father's name of P.T. V.K. Lambada is not mentioned in any of the records, and the ancestors of the petitioners and respondents could not be ascertained during the local inquiry, and this dispute is of a civil nature. However, in view of the order issued by the Special Grade Deputy Collector and Revenue Division Officer J.L. Division, in file number so and so, the name of V.K. Lambada is ordered to be incorporated in Patala of Anis in respect of so and so land, without affecting the position of the occupants, and the parties may approach the appropriate forum for redressal.
yes,
Virtually has directed the parties to approach the civil.
yes,
The contesting the LRs of the contesting respondents, my lord, at whose instance these proceedings were initiated, did approach the civil court.
yes,
My lords were asking me whether, my lord, the revenue records reflect the name of the petitioners. My lord, please, page 283. For the years 2004, 2005. My lords turn to page 284, my lord. Their names have been struck down, struck off.
yes,
And V.K. Lambada is added there.
yes.
It's a fact, my lord, petition, this proof positive to show that, my lord, petitioners' names were in fact incorporated into the revenue records. Page 293. The vendors of the respondents, my lord, whose instance these revenue proceedings were initiated in 2008, my lord, did file a suit, OS number 848 of 2008.
Yes.
And my lords kindly turn to the order. This is the plain copy of the plain. At page 304 is the judgment. Page 304.
Yes.
Maybe
Suit filed for?
Suit filed for declaration as the LRs of VKL.
Yes.
That my lords will get at page 302, my lord. Or page 303. One page ahead, my lord. Declare the plaintiffs as legal heirs of VKL murder and not sir. Memo, may I read the judgment. Memo filed by the plaintiffs 1 to 3, not pressing the suit, is stated by the learned counsel for the plaintiff number 4 died. Plaintiff 1 to 3 are present, hence the suit is dismissed as not present, not pressed. So this is the order which came to be passed. Now, my lords may kindly turn to my lord the impugned proceedings. They are at page 17. The neatly typed copy at page 19.
Yes.
May I read this one. Srisalam and others. You now district have filed application for incorporation of the names against survey number 64 and 65, an extent of so and so, situated at Service of Village Shamshabad number to AP online ID number so and so. On verification of documents filed by the petitioners, petitioners have purchased the land from Sri Yarukula Shankar and others, son of late Bhalia, Palma village to a registered singly dated so and so, registered at Shamshabad and submitted proceedings. Dated 3/4/2007, issued by the RDO, Chevala Division, proceedings number 18 to 2008, issued by the Tahsildar, Shamshabad. Well, these are the two proceedings which my lords have seen just now.
Yes.
Accordingly, a notice in form 8 of our Act was issued calling for claims and objections by persons having any interest for the said land within the stipulated period of 45 days and published by the village revenue officer concerned on notice board of respective Gram Panchayat. In response to the above notice, no objections were received within the stipulated period. Note that no notice, my lord, was issued. Probably, my lord, form 8 was issued. Notice, my lord, as contemplated under 5.3 was not issued. Reading further, my lord. Further, the applicant has submitted the court order in OS number so and so dated 31/12/2009, passed by the additional junior civil judge. Come 17th Metropolitan Magistrate at Rajendra Nagar Katri, that both the parties have compromised.
Yes.
But parties never compromised. The suit was, my lord, in fact, my lord, withdrawn.
Yes.
Now, based on this, my lord, an order came to be passed now. On the premise that the parties, my lord, in the suit have compromised and there is no dispute.
Yes.
And local inquiry is revealed that Sri Vikyala murder so and so was patadar of land in survey number so and so, situated so and so. He expired long back and his wife so and so so on. After all this, my lord, in view of the above, is hereby ordered to incorporate the names of the following purchases in the revenue records of Palmukal village, by deleting the names of the seller from the record. My lords, look at the impugned order. Look, the dispute with regard to, my lord, who are the LRs of the original PT has not been resolved.
Yes.
The then Tahsildar has clearly passed an order, my lord, that since it's a civil dispute, the parties are relegated to the appropriate forum, which is civil court.
Yes.
My lord, a suit came to be filed, which was withdrawn. And the same suit, my lord, is referred to in this proceedings, saying that, my lord, it was compromised between the parties. On the face of it, my lord, this order, my lord, cannot be sustained on both grounds. One, my lord, that it doesn't, my lord, it has not abided by, my lord, the the principles of natural justice as provided for under section 5(3) of the Act, as well as, my lord, on the face of it, my lord, the decision, my lord, to incorporate these names was based on an order which was which is not in existence.
Yes.
On both these grounds, my lord, the proceedings are up to, my lord, to be quashed.
Yes.
Question number 5. Please. Lordships are got communicated with this tax card. Lambada, the admitted banking, the 38 certificate was issued in favor of Lambada on 18/1/1973. And Miller, after his death, the names of his LRs were located in the revenue records, and they were also issued individual Patadar passbooks and LOTDs as per the Repeal Act and the Repeal Act with their respective entitled extents. And those documents are also filed with the Patadar passbook. LRs of protected tenants in turn sold in the year 2001, that the first tablet statement your lordships have seen in the record, right?
Yes.
For valuable sale consideration to one BB Agarwal, who purchased the entire extent covered under the PT certificate.
Yes.
In the year 2001. And consequently, the name of the BB Agarwal was mutated in the revenue records. And for your lordship's query, my great friend has answered that Panis has been shown, which is your file, in which the name of the BB Agarwal is shown in respect of this survey number after issuing the mutation orders. BB Agarwal in turn sold to my client, that is Syed Adil Ahmed, who is the petitioner number 5. In the year 2002, within 1 year. The name of the Adil Ahmed, petitioner number 5, was also mutated in the revenue records, which is at 11/10/2002. These dates are important because first mutation proceedings are 2001. And later on, Adil Ahmed, petitioner number 5, name is mutated by virtue of the proceedings dated 11/10/2002. Again, the petitioner number 5 sold a major portion of the land in favor of various other petitioners itself, which is a second tabular statement, page long tabular statement. The fact remains that by the year 2002, all the petitioners became the absolute owners of the property through the register and sale deeds. Their names were mutated, and the mutation proceedings were implemented by showing their names in the year-wise Pahanis, which are filed before your lordships. They have orchestrated, a typical modus operandi has been filed in this case. Your lordship is well aware, if some X comes and makes a claim for mutation, whether rightly or wrongly, if my name is existing there, they are bound to give notice under 5(3) your lordship. So to avoid that,
Why you have not questioned those two orders in this repetition?
we were not no knowledge of those proceedings.
By the time you file this repetition, you have knowledge. You file those copies of the proceedings.
But ultimately, 2010 order, which is your lordships may kindly see, the both orders were read to your lordships, which is
That these 277 and 280 proceedings are issued behind your back.
Yes, 2007.
Through which your names were deleted from the revenue records.
Yes.
Why you have not challenged those two orders?
Because they were not communicated to me. You are not the parties there.
That is a good ground for a challenge.
And what happened? This 2007. What they have done is, by this time, 2007, when RDO interfered in the matter by way of appeal, just they filed a petition saying that all the entries are the wrong entries. That means the entries made in respect of the LRs of the BK Lambada and BB Agarwal group, Adil Ahmed, everything is wrong. And he says that without issuing any notice to the persons who are as per their own revenue records, their names are reflecting.
Can I decide validity of those proceedings now?
No, that's why in the second proceedings, also third proceedings, which my learned friend has read, he has clearly stated this is a civil dispute. They should have stop the proceedings. By next ultimate paragraph, by deleting the names of the present Patadar and incorporating the names of the some third parties.
RDO already set aside that by the time. RDO already set aside all the entries right from 1990 onwards.
Remanded back.
Remanded back.
To MRO.
Yes.
MRO, what they have done is, after remanding, because once RDO without any notice, RDO Miller, our names were removed without notice, and some third parties who made filed an appeal, the BK Lambada original owner name was recorded again, so that our names do not appear. And 2008 MRO passes order by deleting all these and making corrections. And 2010, he says that they are the legal, I can't decide, but in view of the RDO order of 2007, I am removing their names, and then after 2008 order, clandestinely they go and execute the sale deed, the Jalpal Shankar and others who made rival claim. They executed a sale deed in favor of respondent and 4 to 6, and they filed an application for mutation. And when they filed for application for mutation, naturally, Miller, by virtue of 2007 and 8 order, BK from the Lambada name is restored. My humble submission is in all these factual scenario, Miller. Now, even remanding also, nothing is because their main claim.
Assuming that it is allowed in impugned order of the year 2010 is set aside.
2010 is set aside, and once it is set aside, Miller, for the persons who make the rival claim, Miller, because my names are existing from the beginning.
Your names were deleted in 2008.
2008 it is deleted.
You didn't take any steps.
Because we came to know only in 2010.
Even after that, you didn't take any steps for 13 years.
In 2010, because when their names were mutated, Miller, we came to know. And when entire issue has been.
You came to know that your names were deleted through such and such proceeding.
Proceeding, and 2010 their names were incorporated. 2010.
10 incorporated, but your names were deleted in 2008 by virtue of order passed by the MRO. And till now you didn't take any steps.
Continuous action, because what they have done is, they have first ensured that the BK Lambada, who already whose legal heirs have sold the property, there are series of registered sale deeds, series of petition proceedings, and they went after this 2008 proceedings.
Even if it is allowed, impugned order is set aside. What happens?
Their names will go, Miller. The persons
who make the rival claim will get restored. PT names will get restored. Original that deceased PT name will get restored.
And if they want, they go to civil court, and because you will learn to say that they simply withdraw there, and RDO says that the matter is compromised with the original LRs of the tenant.
Yes.
The submission is that the person who makes a rival claim against the real owner as per the record, it is for them to go to civil court and agitate their rights.
Yes. Who appears?
Even others, my lord, on the 5-3, even if my names are not, my lord, are struck down, still, my lord, being an interested person, Lord, 5-3 says, my lord, 5-3 read with 15, rule 15 says, notice should be, my lord, issued.
Yes. Mr. rightly pointed out, earlier proceedings which have been issued in my favor, my vendor's favor, they have not set aside subsequent proceedings. Now they are challenging, they have filed the proceedings, they have not challenged. This Court rightly pointed out, this writ itself is not maintainable under ground. One more thing, the entire the petitioners are confusing this court. There are 3 proceedings. There are 3 ORCs. So Lakshmi kindly note it. One ORC is in the name of BK Lambada. To an extent of
ORC or PT?
ORC No, PT 38.
Yes.
Total extent of 8 acres, 38 kuntas. White PT certificate number LRW public 76.
Yes, no dispute on that.
Yes, there are 3 PTs, Now they are claiming through Jairam Lambada. Son of Jairam Lambada, now again they are claiming through son of Jairam Lambada, who is also BK Lambada. They have sold entire their land. Jairam Lambada has sold entire their land. Now after selling 8 acres, their extent is 8 acres, 35 kuntas. Now in the name of BK Lambada, now again they are selling my land.
they have only 8 acres 35 guntas through Jairam Lombard, according to Miller's their PT certificate.
Yes.
Now, by virtue of Miller's in the name of B.K. Lambada, again the son of Jairam Lambada, Miller's the parent number 7, Miller's in of my counter. Miller's now they're selling the property, my property.
No, we are not concerned with selling and all that. You are not before this court.
No, I'm not before.
Yes, they came before this court questioning the impugned order.
Yes.
And where is the compromise referred to in the impugned order?
Miller's actually, there was a compromise, Miller's out of court settlement. Miller's they have
Compromise with whom?
Miller's compromise between Miller's now somebody is claiming Miller's, some third parties are claiming. Therefore, they have compromised.
No, did he compromise with the petitioners?
No, Miller's petitioners, vendors of the Miller's
How
petitioners.
can that be? Petitioners have purchased
They
and
are claiming Miller's, therefore Miller's, they have compromised.
no, if somebody claims and if you compromise, how can the rights of the petitioners?
But Miller's, that material is that Miller's, I asked my client Miller's recently they came to me. Miller's, I'll file it within 2 days, entire
No.
material, that
No
compromise.
question of adjourning the matter. Yes. You make your submissions. No question of adjourning the matter on any.
Material is not available. Only 1 day, give me time, Miller's, so that tomorrow.
13 years have passed.
Yes. Miller's last time, Miller's entire submissions have been made.
Yes.
Miller's, tomorrow, Miller's, so that I got material today itself.
Yes, yes. Anything?
So that I file. I'll file it, Miller's. Only 2 points. One is Miller's, this unbefore rightly pointed out, Miller's, there are 2 orders which are not being challenged. So subsequent proceedings cannot be challenged. Miller's, unless until that can be set aside.
No, this can't be a consequential proceeding or anything to those 2 proceedings.
Yes, Miller's, exactly consequential proceeding.
No.
Last way kindly go through, Miller's. My vendor's name have been mutated. Now, Miller's, I purchased the property, Miller's, from my
Where
vendor.
is your vendor's names mutated?
Miller's, exactly. Your last way kindly see the proceeding. My vendor's names have been Miller's, restored.
So your names are entered. Your names are entered by deleting the name of BK Lambada,
277.
not the legal heads.
In view of the above findings, wrong entries made in the Pahanis from the year 91 onward, we rectified and incorporated name as BK Lambada. Who is my Miller's vendor?
He is not your vendor.
My vendor's father.
Yes. Where is your vendor's names mutated?
No, my vendor's father, man.
Yes. That is a dispute.
Yes, man.
And you your vendors filed a suit to declare them as legal heads.
And that with regard to some unauthorized persons, Miller were claiming, Miller, they filed it recently, Miller, they have approached Miller before the lower court. Lower court has dismissed their Miller 39 Rule 1 and 2 petition. They are not in position, Miller. They are claiming through one Miller who is the name of BK Lombard.
Yes, because your names are there in the revenue records, obviously that petition.
Yes, mine is Miller, there are 3 speeds. One is Miller 8 acres 38 meters, one is 8 acres 35 meters, another Miller 8 acres. Miller, they have sold their respective land. Miller, they are claiming my property. By virtue of unauthorized sale list, Miller, now they are coming and Miller, they are trying. Even Miller, that to substantiate Miller, even their vendors are not being Miller legal safe BK Lombard. Their names, Miller, I will file it, I have records, total list, everything.
Both of you go and establish that in a civil court as said by the MRO. Why did you go before Tahsildar again?
Miller, that
the
they have not
resolving
challenged
the issue.
that they have not challenged that. That proceedings have not been challenged because it's unlawful. They filed it, but Miller suppressed. Wantedly suppressed.
Yes.
That's what entered material Miller's. Now I will prove that Miller, even their vendors are not in Miller's legal case. I have entered material.
Yes.
Let's kindly give tomorrow Miller, I will file it Miller that material.
No. Any other connected matters to this?
No. Rest of my knowledge.
Assessment by other landscapes.
The
writ also lordship with the lower court, they filed a suit for injunction that was dismissed. Your Lordship. Dismissed in that two writ petitions to the mentioned.
You are appearing for?
4 and 5, Your Lordship, we already filed a counter. Filed under Your Lordship, that suit for injunction was filed. That was dismissed, Your Lordship, filed by the petitioners.
You are appearing for R6, huh?
Let's, R5 months.
He says he
For R4 is okay. Please tell him.
Please, sir. Your Lordship, in this matter, from 4 to 6, Your Lordship. 4. And Your Lordship, this is out of copy. In this, Your Lordship was dismissed. When dismissing the application, Your Lordship. Put the report is regard to two judgment and the two repetitions.
First, repetition, my lord, refer to. First repetition, my lord, in the proceeding appears to be, my lord, unrelated. So the party names are entirely different.
That one.
Maybe some other proceeding drafted in this.
Yes, sir.
19415, Your Lordship, that was mentioned in the
That is this repetition.
lower court.
That is this repetition. That is the repetition is now listed.
Right.
Is anything you want to add, Mr. Ramanujan? Okay.
Lordship, in this matter, there are the Lordship of kindly says that lower court order, Lordship, the dispute with regard to identity of Lordship.
All that we are not concerned. We are concerned with the impugned proceeding.
Proceedings, Your Lordship, there are 3 protected tenants, Your Lordship, persons purchased from 3 different persons. Whereas our clients, our petitioners was purchased.
Yes.
And Your Lordship, that there are
Purchased litigation.
not Your Lordship, 3.
It's obvious.
Bakia Lambada, Jairam,
ఏం లేదు ఇంకా
and Sevia Lambada.
Your Lordship, plus 2 references and send the target to connect the intent was very easy.
And tomorrow, Your Lordship, 10:30 at the first
ఇంకెందుకు
matter,
అయిపోయింది ఇంకెందుకు
first matter, Lordship.
థర్డ్ త్రీ 7 kilometers. And then it becomes 7. Source and source means not.
Item 28.
What is it your lordship? Finally, access matters tomorrow, your lordship, for verifying the reply.
You wanted Passover.
Reply was served on Thursday.
We
Expecting.
verify it and argue tomorrow.
I will argue tomorrow. Tomorrow will be. I will argue today because I am personally present. I will complete my.
Yes.
I will. Are the owners of the land.
No, that's all right. It's all right. The dispute is about identification.
Now, I filed also. You also kindly see the reply filed by me.
Yes.
Now they are saying that I am not the owner.
No, they are not saying you are not the owner.
Now, you also kindly see page number 2, paragraph 5.
Counter.
Yes. Reply to paragraph number 3, it is admitted that the petition may be put to strict proof with the government made in this paragraph that the petitioner so and so is the owner of the land. Not owner of the land, that inquiry will be gone into at the stage of award inquiry. I filed counter for this. Reply for this, not paragraph page 3, paragraph 5. Reply to the government made paragraph 5 of the counter affidavit is submitted that the second respondent having already issued a draft notification while the fifth notification dated 8/2/2000 issued under section 4(1) and the declaration under section 6 while present notification dated 7/6/2000 for acquisition of the land of Nemuri Lakshmama.
Yes, yes. Yes, next.
Now we cannot go.
Yes, next.
Will also kindly take my reply. Page number 15 is my title list.
Yes, that you don't have to labor on that.
Yes. In the page 80, counter filed by the special deputy collector in earlier page 19. Yes. In that they admitted, you have to kindly page 19, paragraph 5. It is submitted that the land mentioned in the petition was notified under Land Acquisition Act. The draft notification was published 17/12/1999 with other persons' land in same Tigalaguda village submitted as under page number 20. Tigalaguda, survey number 26/1-2. My name is also reflected in the 1999 itself.
Yes.
Now I also filed declaration which was filed, notification which was issued under 4(1) on 8/2/2000. That is in my expedition page number 14, page number 19.
Yes.
Now at this stage, now they cannot say that I am not the owner.
What about they say about acquisition?
Acquisition, they said that
About laying of the road.
they did not say anything in this counter affidavit. But in the earlier counter affidavit, you will also the very same commissioner. You will also kindly once again kindly take that counter affidavit. Sorry, sir. You will also kindly take the order of the learned single judge who passed the earlier writ petition, page 22 of original writ petition. At page 25, paragraph 9. However, the council for GHMC, that is the sixth respondent who filed counter now.
Yes.
Sixth respondent states that the sixth respondent is willing to pay the compensation as determined by the first respondent 1 to 3, and he has no objection to send the requisition to the first respondent to notify the petitioner's land so and so. Now he cannot say now. The very same
Sixth respondent now filed the counter.
So this is in respect of some other petitioner. In your case only.
Not in my case. Very same land, very same
Acquisition.
survey number. Acquisition in the earlier.
Yes.
No, he cannot go. If he has got any grievance against this, he has to have filed a review or a writ of appeal. The sixth respondent has not filed any review or writ of appeal. That has order has become final. On the other hand, the government who is requisition authority filed
No,
a writ of appeal.
this para 9, it says about petitioner in that petition.
Petitioner in that petition.
Yes. How can you take that statement to your case?
No, not in my matter. I am asked. I am representing in this case. They say that this representation made by the council for the sixth respondent is the sixth petition. Now they are disputing.
In respect of petitioner therein, they said they will initiate proceedings.
I am saying with the very same survey number 26/2, 26/2 and 1.
No, if that is accepted by them, it's straight away covered.
Now the notification itself says my name. Now they cannot go back for this against this budget notification. Please kindly go to page number 16.
Yes.
On page number 14, it starts section 4.1 notification. Page number 16, survey number 25/1/2, TS number 167, Lakshmana Nemuru, the petition given 19 cents. The next 26/1/2A.
So in the counter, they say anything you are saying that this is not acquired, now they are not utilized for road.
No, what they are saying, you will have to kindly see. Once again, I will read the paragraph 5.
That they are disputing your title, that's a different aspect.
No, they admitted that there is a notification with regard to this land.
Road వేసామంటున్నారా వేయలేదు అంటున్నారా ఇక్కడ?
What they said, the petitioner himself has failed to identify land. Now they are asking me to identify where is my land. I denied that.
Where they say that?
Paragraph 8. It is submitted that as per the directions of the Honorable High Court, this officer has addressed a letter to the Special Deputy Collector Land Acquisition dated 18/10 with a request to furnish detailed report and memo dated 17/12/1999, which I took your lordship in the counter. And so on, dated 18/3/2000 under section 5A. Further, this officials along with the deputy inspector survey land acquisition officer has conducted a joint survey in the presence of the petitioner, and verified documents submitted by him and found the petitioner himself failed to identify the land and also failed to show the land which was affected under the road. My lord, admittedly 21/1/2 was laid road and he paid the compensation. In the you will have to kindly see in the very same counter paragraph 7.
What is your reply to this paragraph 8?
You will have to page number, page 5, paragraph 7. I submit that the allegation made in paragraph number 5 and the counter of it are absolutely incorrect and false. It is submitted that on 18/10/2023 we have shown our land to the assistant city planner and other officials who come to inspect the land. Our land is just adjacent to the land of Mr. G. Ranendra, the writ petitioner 218836 of 2000, to whom the respondent have paid compensation in pursuance of the order so and so. While the award dated 10/2/2020, it is absolutely false to say that we could not identify and show our land. In fact, we have clearly shown our land in an extent of 19 cents in so and so, and 21.5 cents in TS number so and so.
Now total land is affected or any land remained?
Total land is affected. 19 guntas and 21.5 guntas.
21 guntas is of somebody.
That is G. Rajendra. Next sentence is important. I submit the respondent having laid road in our land after publishing the draft notification under section 141 declaration under section 6 cannot say that we could not identify and show our land. It is nothing but playing fraud on the citizen.
Yes.
I am relaying two judgments.
Yes.
2013, one SCC. You must be aware of this. This is Tukaram Joseph and others. Paragraph 10. In this case also, below that
Bombay High Court dismissed on the ground of delay. Against that, the petitioners carrying the matter to the Supreme Court. What the Supreme Court said at paragraph number 10 and 11.
Delay issue may not be.
Yes,
Delay is not a.
delay. In the paragraph 11, my lord, 10th line.
Yes.
The appellants are asking repeatedly for a grant of benefit of the compensation. The state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. There is a distinction, a true and concrete distinction between the principle of eminent domain and the police power of the state. Under certain circumstances, the police power of the state may be used temporarily to take possession of the property, but in the present case, clearly shows that neither the said powers have been exercised. A question that arises with respect to the authority of the power under which the state entered upon the land. It is evident that an act of the state amounts to encroachment in exercise of absolute power, which in common parlance is also called abuse of power or use of muscle power. They further clarify that the position, it might be noted that the authorities have treated the landowner as a subject of particular in India, but not a citizen under the constitution.
Yes.
Now, admittedly, they laid the land. They laid the road on my land. And now they are saying you have to identify my land. Having issued section 41 notification and also 6 declaration.
Yes.
And also another judgment also 2020.
Vidya Devi.
Subsequently, after this is also considered that Tukaram, Rana Joshi, and also Vidya Devi. This is Ravindra Bhatt and P.S. Narasimha. But in this case, the government said that
Yes, I have considered this in another case.
Yes.
Yes.
Paragraph 11 and
Yes.
now this case,
Yes.
they cannot go back.
Goes to but the request of land standing council for respondent goes to yes. Let them thoroughly verify and come. Otherwise, it's a prima facie court feels that it's a fit case for imposing heavy cost.
But I am also
Unlike in the other writ petition, it will be heavy means heavy. Let them verify thoroughly and come back.
I am requesting Millard to impose a absolutely cost more than 1 lakh rupees in the senior IAS officer who files a false affidavit before this court.
Yes.
Item 35, A. Prabhakar.
Yes. Listed on the screen. There was no representation for considered the director to be listed in the action dismissal. Then the matter is listed in the action dismissal. There is no representation for petitions either in the session or post.
Item 37, G. Venkateshwar Reddy.
Yes, sir. Consider change the consider. So, pursuant to page 14, no proposals are submitted by Tahsildar.
Not submitted.
So, I'll direct Tahsildar to submit proposals and then pass orders on.
Please, please, petition. earlier date of 2/11. This is what we call this. Non-prosecution is same, the date of 2/11 date. Yes.
Item 42, B. Shivakumar.
Yes. Disposed of. In terms of that, I will discuss. Pharmacity.
Yes, Madam.
Into matters ఉంది కదా. Yes.
Item 7.
Yes. Yes.
Only I'm interested in 3 days.
3,000.
Next time.
Not next time. Today also you have. Let me hear him. Let him start at least already anyway, it won't be over.
Yes, it won't be over.
Yes.
Revision authority.
Before working on that one.
Taking the orders through the order. Hit the tax order. It will do this.
Include order 15/11/2004.
Yes.
Yes.
Same other those one.
15/11/2004. I'll just indicate the, okay, this case and there isn't.
Yes.
Petition before you have got. Or the. Laws of. Who was admittedly the owner of the property. Property is a total extent of 91 acres, 25 acres, 3 survey lines. Give the details of that. What happened? There are three persons. They will not filed an application. But they names to be recorded under Form 10 of the rules, that is change of name. On the ground that there is a unregistered, the statement in their favor, dated 15/10/1957, executed by
15/10/1957.
That is what is that is executed by the mother. That is who was admitted to the owner of how to do it is the son. But Muhammad is but what happened? They filed an application. Not in the year 1993 before the small to incorporate their names.
And those applications, 3 applications filed by the 3 alleged purchasers, they were dismissed, they were rejected on 10/4/1993. The paper book I have filed, you will also be kindly get 10/4/93 order. In respect of all these 3 people, not at page number 5, you will also be kindly get that order. 10/4/1993. This is in respect of Hanumanthappa. 3 people will not who have set up this document, 5 million.
Yes.
That is an application filed by Hanumanthappa for transfer of Milord, the name in his paper, change of name, 28 acre, 35 hectare. And the order says, I read Milord this short of it. Form number 10. Hanumanthapur Grammam, survey number so and so. హరి చేసినారని అటు నెంబర్ మీ పేరు పట్టా మార్పు గురించి కొనినారు ఈ విషయంలో రికార్డు పరిశీలించగా సమర్పించిన కాగితం ఒప్పందం ప్రకారం పట్టేదారుకు ముద్ర పూర్తి రొక్కము ముఖ్యంగా ముట్టినట్టు లేదు మరియు ముట్టినట్టు కూడా రసీదులు చేయలేదు కావున దరఖాస్తు తెలియదు. But any of the fact remains that cannot be very agreement cannot be the document is disputed. But anyhow, this is the order passed by the officer at that particular point of time. Similar order is passed. This below next page is endorsement in English. Translated there. Then may not be. So for page number 7 is in respect of Pentappa. Same order is passed. Page number 7. Your officer, please to get it. One is order 5, translation, order page number 7, translation page number 8. Yes. So far as second below person is concerned, that's Pentappa. Now the third order at page 9 below. Same order is passed, page of Putama. These are three people below that in whose favor it is rejected. Now when it is rejected, there are no further right in the problem. Because that form number 10 is rejected. Now suppressing all this, they file an application before the Mandal Revenue Officer on 23/6/2001. This is happened in 1993. Then after Matta also has been granted to Taj share.
23/6?
23/6/2001. Suppress this document, these orders, they file a petition for issuance of 13B certificate straight away. On the ground that the unregistered sale deed, they want regularization of that unregistered sale deed.
Form 10 is also for that purpose.
For the same purpose, but they suppress that. They suppress this and they file this petition. And the defense is this. Defense is.
Where is that application?
That application.
23/6.
That is not there, but in here that referred just say. But yesterday, if the record has come with it. Then when that application is filed, the MRO stated that the objection raised is this threefold. One is they were already the petition was dismissed on 10/4/1993. Copy has been filed. Specifically, it is referred to. In the light of that, the petition dated 23/6/2001 for 13B certificate is not maintainable. And assuming that any inquiry can be looked into, that the order ought to have been referred to because already rejected. The inquiry into genuineness of this particular document, once it is disputed as fabricated, the contention is that it's fabricated. No doubt in those orders passed in 1993, we have stated that you are not paid the entire amount, whatever it is, but the fact remains that we are disputing the genuineness of this transaction. Without reference to the order dated 10/4/1993, no reference at all, though that is a specific objection. The orders dated 10/4/93 MRO does not refer to that at all. And he goes into the inquiry into the matter. He cannot inquire as per the judgment of the summary report. It's only a summary inquiry. He says, I have examined the villagers. They have stated that what is the agreement is true. This sale deed is true. Hence, 13B certificate is issued. That is confirmed by the RDO without reference to the 10/4/93 order and without reference to the fact that this particular the genuineness of this document cannot be gone into. Under inquiry will conducting 13B. The same order is confirmed by the RDO against which the requisition is filed. That's all the order. Kindly see
Not the objections filed before the MRO. And the order passes thereafter. These objections were filed.
No, it is against orders of joint collector.
Let's straight away go there. That is it.
No, let us see the order of the Tahsildar first.
Yes, order of Tahsildar. That is at page 63. This is revenue return. At page Tahsildar order, page 63. Yes, page 63. Kindly see, my lord. Lachamma, Ventanna, and others of purpose of filed a petition 23/6/2001 with the request to issue 13 certificates in respect of these lands. Now, my lord, there are two, my lord, all that may not be necessary. Unless it's, in this case, verify the record pertaining to lands. OOB, that is so was the original Patandar of said lands. And after that, these lands were made in the name of Farsa Taj Muhammad. During his lifetime, the original Patandar had sold the said land. He comes to the conclusion, said land to Hanumantu, the stamp paper 15/10/57. His son of Hanumantu has also received some amount from the purchaser, executed under his own free will, dated so another document. Again, convince the cultivator to purchase the land on the basis of an agreement of sale of 8,000. Then, while submitting the check, stamp paper from the free will, file a petition to incorporate his name as the cultivator. Mahadesh on this petition. So, we are passing here for once. Kindly come out to, at page, just back to this petition, this another crucial document. They have surrendered all this. This land has been surrendered by them also. Those documents also have filed before the those surrender documents. At page 45, I think in the 48, 45, page 45, kindly stick for this document. How they have surrendered. All this may not be necessary to go into by Tahsildar. How they have surrendered, page 45.
What is your objection filed to this?
Objections are what happened, subject to your lordship's pleasure. This order was, my lord, our case is antedated because we have filed objection. And then, my lord, then the Taj Muhammad died in December. Thereafter, we obtained certified copy and filed the appeal before the appellate authority. Our case is that, my lord, kindly see the objections filed, my lord, at page 60. So they were dated 29/10/2001. So, and the order of Tahsildar is dated. This is antedated in our case. That's what we have stated in the appeal grounds also. 11/10/2001. But let us see, this is a consistent objection, not throughout. Kindly see page 60. Respondent is absolute to owner. There are 4.
Page 60, na?
Page 60. The respondent or they have not sold the said land. There are 4 members.
Yes.
Respondent or the ancestor have not sold the said land to the petitioner or anybody else, and the respondent have not executed any document in that regard. The alleged sale of the said land set up by the false concocted and baseless. Then, my lord, so far as Para 6, my lord, the petitioner had earlier also made a similar attempt by filing false case in file number so. And the same was rejected on 10/4/1993. So these 2 points may not have been submitted. There are 4 and there are 6 are relevant. Now the MRO does not refer to all. And see the order of the audio walls. Before the audio walls, the same contentions are raised once again. Kindly see the appeal grounds also. The appeal grounds. Candidate. Grounds, my lord, at page 72.
Same day he passed the order. The date fixed for hearing and on the same day he passed the order.
Now kindly see 72, my lord. The same grounds, we are raising the same grounds everywhere, my lord. This 72 also it's affidavit. And grounds, my lord, at 75, appeal grounds. And we have very clearly stated there are 5, my lord. It is that is at page 78, my lord. This is appeal grounds. Round number 5. It says that the exhibit 15/10/57, it is false, concocted, baseless, and forged and fabricated. That's it, ground number 5. Ground number 7, there is already previous order dated 10/4/1993. Kindly see ground number 7. Ground number 10, my lord. The MRO Zairaba has not communicated the order allegedly passed on 11/10/2001 till now, and the appellant herein had to obtain certified copy of the same on 4/1/2022, and as such the above is within limitation non-communicated. And this is that man admittedly died. Got during December 5/12/2001, got he died. That is the Rajma.
Yes.
Then my lord, even in the revision petition, you will not will kindly see the same arguments are taken written after before the written revision petition also. You will also will kindly see. Page 1
Yes,
to 3.
tomorrow.
That is it.
Or some other matter.
Seems to be powered by this. It's just pass on.
They have to.
Bench, huh?
No, single edge only. No, what it says is, five-way inquiry, the certain B certificate being issued. That the particular is in 5B. The court has no jurisdiction to decide the matter. And see, the moment there is a dispute with regard to the document.
Yes, yes.
The audio is out of, no, they are number of cases.
That is settled.
That's settled. That's all.
Last day after tomorrow.
Yeah.
No, let him stop there tomorrow. I'm ready tomorrow also. Kindly have done Friday. Because I am already ready. Today.
No, you already argued.
What?
You already argued the matter.
Okay, but
If required, I'll give place. Let somebody here.
but pass on arrangement.
Yes.
Just pass on.
That's the kind of pattern in
No mention, no mention. I will. Sign what I will.
Your losses have not signed, you know. I was at
Sign చేసేస్తాను మార్నింగ్ కూడా లేరు ఇప్పుడు లేరు
kindly similar. Two of my colleagues are not reported today. Tomorrow we are old matter. I can 35 that.